Hello, everyone. We're running this again tonight. Mr. Lau is back. All right, I saw some people waiting in there. Maybe some kind of little glitch. I see. All right. All right, yeah, we just gonna get it going because this is gonna be a long one tonight. So, uh, let me get this straightened out real quick. There we go. Now I can pop on the side. Hello, everyone that's popping in. All right, there you go. Sorry, everybody waiting. I just didn't see comments yet. I said, well, I'm gonna get started while nobody's in there. So hello, everyone. Yeah, let's get started. So we have Mr. Lau, and we're gonna be here a while. All right. So let me get this going, and then we'll be talking throughout the video. Let's go. Well, this is the second hearing with all this parking enforcement. You see, there's more people in the courtroom. He's already sitting at the desk over there. So it's gonna be some testimony and all that good stuff. So we're gonna roll into it.
Okay, we are on the record. Just check in with the parties here. We have Mr. Lau here. We also have Mr. Reynolds and members of the Community Vitality Program here as well. Mr. Reynolds, are we ready to proceed from the city's perspective?
We do have a matter that I'd like to take up prior to the initiation of the trial on these parking tickets, Your Honor, as it pertains to some subpoenaed witnesses.
Okay.
So I do understand that Mr. Lau himself served two subpoenas, one to Mr. Leo Pelli, who is a supervisor in Community Vitality, and then the second subpoena to Ms. Jean Friedberg, who is a community member and sitting in the back of the courtroom right now. And I would request that Mr. Lau make an offer of proof to the court as to these witnesses' testimony, because it's the city's position that neither of them have relevant information and should be not feel compelled right now to be here. I also understand that Mr. Lau himself served these subpoenas, which is not in compliance with the rules of municipal court procedure, should be served by somebody over the age of 18 who's not a party to the case.
So it sounds like what you're orally moving to do is to quash those subpoenas. Does that exactly sound correct? Okay, so Mr. Lau, a quash just means cancel the subpoenas, and Mr. Reynolds has indicated two bases for which he says that these subpoenas and the requirement that these two individuals remain in the courtroom and participate today. The first is that there was improper service. Under the rules of procedure, Mr. Reynolds has pointed out the rules of procedure require that someone who's over 18 and not related to not a party or related to a party provide service of subpoenas. And so he's indicated that the service that was achieved, and I think you said, obviously I know Mr. Pelle's name, but did you say?
Ms. Friedberg.
Friedberg, thank you. Let me write that down. So Ms. Friedberg, that both of these folks were served by you individually, so the service was not proper. Do you want to respond to that?
Yes, Your Honor.
Left-handed RN, thanks for becoming a member. Appreciate that. Glad you're a part of the trust now. Thank you. All right, and hello to you too. All right, hello there. Everyone that's coming in saying hello. Hello to everybody. Glad you're in here. And oh, that's okay, left-handed. I see your message. Yeah, it's all good. Thanks for coming back. I appreciate that.
Go ahead.
Okay. So of course, I emailed the court. The court administrator is the lady. Of course, she prepared the documents for me and gave me instructions on how to serve them. And I follow her instructions. And of course, I also sent the copies back to the court, believe to her or to the court, that they've been served. So I follow the instructions given to me by the court administrator.
Tell me what instructions you're talking about, because it's one thing, she is required to prepare the.
How
prepare
to
the
serve it,
subpoenas.
yes. So.
If you have an email that you want to share, I'll certainly look at it.
Sir, if I may, I'm the one that sent the subpoenas to Mr. Lau.
Okay,
I did make a mistake in telling that he or his agent could serve, so that was my mistake. So the email came from me and the subpoenas came from me.
okay, all right. It makes it a little more challenging, obviously, when we've put the defendant in a position. Let's talk about the other issues, because that may resolve this. I thought it might be resolved by the improper service, but I think that one I've got a little more problem with, given the fact that our staff provided some information to the defendant. But let's talk about the relevance then. The other argument that Mr. Reynolds has made is that neither the testimony of Mr. Pelly or the testimony of Ms. Friedberg will be relevant to the determinations that I have to make today. So he's asked that you make an offer of proof, meaning tell me what these folks are going to testify to and what case they might testify and how it would be relevant to the determination.
So, Your Honor, yes, I have actually addressed that earlier via email confirmation. So, but if I may ask the court, could the court identify the one gentleman that's sitting in the back who has not been subpoenaed?
That's not important for me to do. No, so what I want you to do is just tell me why you think these two individuals will testify to and why it would be relevant to in case, and let me know what case you think they might be testifying in.
When the court notified me of this trial and the case number and so forth, the 6 trials, pardon me, I've emailed back on January 2nd that I wish to subpoena 2 individuals. That information been also sent to Mr. Reynolds, city prosecutor. And in terms of, sorry, Honor, would you like me to read what I've actually sent in earlier, or would you?
No, I just want you to tell me why you think their testimony would be relevant today.
Oh, okay. Mr. Perry, the supervisor of border parking, as I simply put it, has knowledge of relevant city, throat issue, audience, sorry, but procedures, and directed his staff, who's in court today as well, to specifically target the defendant, me. Prosecutor Reynolds unfortunately lacked these information because I've asked in previous trials, and Prosecutor Reynolds was a little bit vague on which city, 772, whatever it may be, and how the process from the complaint to the tickets to the officer being sent out to the tickets being issued and so forth. And of course, some of them are warnings and some of them are tickets. And Your Honor, in this case, I am referring to somewhere about, give or take, 100 actual citations and warnings over a 6-7 months period. So once again, we're back to the fact that we're having 6 trials today. And of course, this rate, we will have quite a few more trials on different dates. Unless there is some clarity on whether policies and procedures that is approved by council or whatever and codified is followed or not, we will always be trying to address what happened and why it happened and so forth. So that's one of the
suggesting that you want Mr. Pelly to describe what the policies and procedures are for community vitality in connection with the citations that were issued to you.
Yes, especially consider the numerous and overwhelming number over a very short period of time. Because as the supervisor, he also directed his staff specifically to target me, the defendant, because I'm in a hot spot or whatever his terminology is. And until until the June-ish of 2024, I have not had the benefit of such very specific targeting by border parking especially. So maybe something changed.
Okay. Let's talk about Ms. Friedberg then. What do you think the relevance of Ms. Friedberg's testimony will be?
Just limiting it to parking today, because that is the type of the 6 trials that we have today. Ms. Friedberg has been actually, I've observed her, and of course she has observed me on my vehicles on many occasions, but most and border parking staff was dispatched very shortly thereafter, within the same day. But more importantly, the officer who's already in court today has confirmed there were 3 persons that make the most complaints, and Ms. Friedberg is the top of the 3. In fact, there are occasions that the officer has to report to her after the issuance of the tickets.
What are you suggesting the relevance of her testimony would be with respect to the charges that you're facing?
If she truly initiated those calls, whether the telephone calls or whatever, the means to access parking, to have them park in my vehicles, that's number one, whether she did or she did not. And of course, she can testify to that. And if she did not.
But what's the relevance of her making a phone call to the parking services to whether or not there was a violation? Is she going to testify to the facts of the violation?
Isn't it based on the information that I've been able to look at through border parking and access and so forth? It has to be illegal or unauthorized. Some terminology like that. So she would have, somebody who made the call would have made the determination that is.
Mr. Reynolds, do you want to respond to that?
What's that terminology at the website for border parking and access?
Your Honor, it's the city's position that, based off of hearing what Mr. Lau has to say about we'll just take them one at a time. Ms. Friedberg and her testimony that whether or not she may have called to make a parking complaint is simply not relevant, and it's not testimony that would make it more or less likely that these violations occurred. And so I just haven't heard from his offer of proof that there isn't any relevant information that Ms. Friedberg has, and the city is concerned about abuse of process here, that because she's a neighbor here and may have called parking services to report some violations, that it's almost like a retaliatory subpoenaing here. Because we might have more of these trials in the future, I just don't want to set a precedent of Mr. Lau subpoenaing neighbors who may have called to make parking complaints and have them, come into court because they've been subpoenaed, and then them not having any sort of relevant information to whether or not a vehicle was parked with expired tags. That's not information that they can be expected, nor Mr. Lau saying they're going to be testifying to.
Your Honor.
I'll give you another minute, Mr. Lau, to make your point.
Your Honor, in spite of what Prosecutor Reynolds is saying, the fact that the parking officer who's already here in court today has identified her as the one making the largest number of complaints, resulting in the largest number of tickets that have been issued. So of course, he was on duty when he informed me that. And of course, in addition, in addition to this recent round of parking, Ms. Freeberg has been Your Honor, I do not wish to touch on non-parking issue since June of 2024, so I will refrain from making more comments. However, if since she is here, and actually her husband, who is a well-known attorney in Boulder, in Colorado, actually, so I am perfectly open to the fact that whether she or her husband said that she would not wish to testify and then put this whole thing to rest, but just her, Your Honor.
Okay, so you have not established to my satisfaction that anything that Ms. Friedberg would have to say would be relevant to the outcome of any of these 6 cases. The fact that someone may have contacted the police department doesn't mean that they were aware of a violation themselves, that they could actually testify regarding that, and you have not laid any, provided me with any evidence to suggest that she would have anything to testify about these specific instances. So Ms. Friedberg, you are released from your subpoena and you're free to go. With respect to Mr. Pelly, the only thing that you said was that Mr. Pelly was perhaps targeting him with respect to this. And although that's a pretty big stretch for the court to make, I think he has at least a right to make an argument about selective prosecution. I don't know how far it will go. He can ask a couple of questions of Mr. Pelly regarding that. To me, I'm making a big stretch to say that Mr. Pelly's testimony will be relevant to any of these determinations. And I will point out to the parties that the fact that the basic fact that someone has perhaps 100 parking citations or whatever the number might be does not mean anybody was targeted. It may be that there were violations that someone observed and there were citations issued associated with that. And so far in the trials that I've had, that's been my experience, is that there have been citations issued because there was probable cause and ultimately proof beyond a reasonable doubt that those citations should be upheld.
Yeah, but I never heard of 100 on one person within one hearing that they're actually going over.
Each case is new and separate on its own, so I will take each case as it goes along. But I want to make clear to you, Mr. Lau, that the fact that someone issued you a number of citations, whether it was 1 or 10 or 100, has no bearing to me as to whether or not those violations occurred. If they did occur, if we have 100 trials and I find you guilty on a certain number of them, it'll be based on the evidence that's presented in each of those trials.
It depends on the type of citation you get and the jurisdiction that you're in, because a parking ticket in one jurisdiction could be one amount and somewhere else could charge a different amount. So it varies. It's not set in stone how much these violations are.
And that's been the case in these prior trials. So I'm going to ask Mr. Pelly to stay because although I think there was improper service, I think it's probably an error on the court's perspective for providing any legal advice regarding service of process. I will let Mr. Lau know that when the court clerk's office does issue subpoenas, it's up to the defendant to determine how to serve those subpoenas and obtain adequate personal service over someone. So in the future, if you do receive subpoenas, the only information our staff will give you is, here are your subpoenas. And then if you ask questions, their answer will be, I can't give you legal advice, because this is what happens when our staff, in an attempt to resolve questions that people have, provides information, is it may lead to something that's not correct legal information. So I'm going to ask Mr. Pelly to remain, and I'm going to excuse Ms. Friedberg because there hasn't been anything that you've provided to me that would establish that she has any relevant evidence to offer in the case. So Ms. Friedberg, you're free to go. All right. Anything else from the city before we get started?
Your Honor, I know we have 6 tickets, and I have an idea of how we might start them in terms of the order. So we're ready to proceed, but I just want to caveat that I have a proposed order of taking this.
Okay, and that'd be helpful if you do have a proposed order and we could talk about that. So if you'll share that with me right now.
So my proposed order, Your Honor, is to go in time, so earliest to the oldest to the newest ticket.
And it looks like we had some that were issued. So oldest to newest would start with the October 11th. There were 3 that were issued that day.
So I think it's 3985. The one ending in 3985 is the oldest one.
Okay,
And then I have is the number 2 in time would be 3988. And then I've got 3990. And then 4076. And 4077. And lastly, 4078.
all right. Mr. Lau, do you have any objection to that order?
No, since, not at all, Your Honor. Since same officer issued it, I have learned since that it's in sequence based on that officer, so yes.
Okay, we will.
No objection, Your Honor.
All right, we will start then with case number 3985 and work our way forward chronologically to case number 4078. Any other issues that we need to address before we start the trial process from the city's perspective? Anything from you, Mr. Lau, before we start?
There is one particular ticket, there is additional information which I have, it's Ames related, which I have not been able to get satisfactory explanation from both prosecutor and the parking officer, so we may have to address that, but Your Honor, in the sake of time efficiency, yes, I definitely would like to proceed with the trial. Your Honor, if I also may, in previous trials, I have struggled writing and keeping track of the things. If I may ask the court to allow me to receive a video or an audio recording of today's trial, so I may be able to follow up and not spend all the time trying to write everything down. Your Honor, I do understand that there is a professional transcript service that both the municipal court and the state courts use, but their turnaround time is usually 4+ weeks. And also the fact that, of course, in addition to charging some fairly significant amount, but it's the additional time it would take to get a written transcript prepared by them that it would impact, Your Honor, the scheduling of all the additional tickets and trials that I would, of course, hope to have resolved. And we have already expended a tremendous amount of wait time to get to today.
So I'm not going to change the court's process for recording record, for obtaining records. If you choose to get a record of the proceedings from here, you'll have to go through the normal process. And if that takes some time for a court transcriptionist to transcribe it, then that's what it takes. It's not the court's responsibility to record proceedings for you at the court's, at your behest.
No,
you'll have the opportunity to get a transcript, but you'll have to go through the same process that anybody else has to go through.
Your Honor, I do understand that, but there's specific notice on the door that, of course, if for the court that we may not record or anything without the court's permission.
That's right.
So that is why I'm asking.
You're asking for your permission to record today?
No. I'm not, Your Honor, because on the video link and so forth and audio, the court has that, and because this is the information is the court trial, is open records as well. So I'm only asking for the equivalent of a thumb drive worth of information, either audio or video of today's trial.
I'm not going to do that. Mr. Lau. However, I will point out to you that all of our proceedings are recorded on YouTube. It's a streaming service. So,
They are?
yes, so you could go back and look at what happens today on a YouTube video. Go to our YouTube channel. It's on our webpage. You can go to the YouTube channel. You can look up what the hearing date was and actually observe and listen to the actual hearing.
Thank you, Your Honor. If I was aware of that, I would not have been. So that would be, just in case I have, if the court may provide the general information linked to that, and of course the court has my email.
Greg can send you the link to that. It's just on our webpage.
No, thank you, Your Honor. Sorry, my ignorance. I was simply not even aware that
Okay.
the court has been so good in making the information available.
Okay,
Thank
good.
you, Your Honor.
Okay. Anything else that you want to address before we start?
None at all, Your Honor.
Okay, so we'll start with the case that ends in 3985 as the last four digits. This is an allegation that a vehicle was parked in the yard in violation of section 7623. This was issued on October 11th of 2024 at 11:06 a.m. So it's a 7623 allegation. And Mr. Reynolds, if you're ready to proceed on that, you can call your first witness.
Thank you, Your Honor. Call Officer Sean Croteau to the stand.
All right, Officer Croteau, if you'll come forward, sir, if you'll raise your right hand when you get to the witness area, and I'll swear you in. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you, officer. Go ahead and have a seat. And whenever you're ready, Mr. Reynolds.
Thank you, Your Honor. Good afternoon, Officer Croteau. Can you state your name?
My name is Sean Croteau.
And how do you spell your last name?
Croteau.
And Officer Croteau, where do you work?
I work for City of Boulder Community Vitality, parking and access.
And how long have you worked there?
A little over 5 years.
And what do you do for Community Vitality?
I'm a Community Vitality Ambassador, which means I specialize in parking enforcement and also coordinating special events in the city.
And do you do parking enforcement as part of your job?
Yes.
And are you familiar with Mr. Lau, the gentleman seated to my right?
Yes.
How is it that you're familiar with him?
I've received numerous parking complaints and served him over there at 290 Pawnee.
And is 290 Pawnee in the city of Boulder, state of Colorado?
Yes.
Were you working on October the 11th at about 11 in the morning?
Yes.
Where did you find yourself that day?
I was serving complaints that we had held for parking over at 290 Pawnee.
Did you issue some tickets that day?
Yes.
I'm going to approach with what's been marked as People's Exhibits 7 through 15, and as a apology to the court that the order in which we scheduled these tickets don't correspond to the numbered exhibits.
That's fine.
But
It's okay.
Mr. Lau has previously been furnished with copies of all these pictures, and then today has been furnished with exact replicas of how these exhibits will actually look. Officer Croteau, can you go ahead and just take a look at all of those pictures, please? And do you recognize those pictures?
Yes.
How is it that you recognize them?
They are pictures for a citation that I gave for a vehicle in yard.
Did you take them?
Yes.
Are they fair and accurate representations of the scene that day?
Yes.
At this time, I'd move to admit People's Exhibits 7 through 15.
Mr. Lau, do you have any objection to those exhibits 7 through 15? If you need to take a moment, you can.
So, Your Honor, no objection to most of them, but 12, 13, 14, is that 14? Yeah, 14 and 15 refers to at least another trailer unless prosecutor, not the center of attraction. Well, what about this one? There is no. So.
Let's do them one at a time. So
I have no objection to the omission of 7 through 11 for accuracy.
All right, what's your objections to exhibits 12 through 15?
12 through 15 really refers to another trailer that I have been cited, both warned and cited on many occasions. So, yeah.
And Mr. Reynolds, I'm looking at exhibit 12 right now. What is
Yeah.
that?
Well,
Supposed to predict?
Your Honor,
Corner of that.
Your Honor, the city admits that not all of these pictures show the actual trailer, but because we have to prove that the trailer was in a yard, those pictures are of the yard. And so that's the relevance of those pictures, to show that the trailer is in the yard, that it's in the yard because they were taken portrait mode and not landscape. And so it's portrait. And so we have to prove that they're in a yard and there are pictures of the yard.
Okay, I'm going to allow exhibits 12 through 15 as well as exhibits 7 through 11. So all 15 exhibits will be admitted. You can proceed.
Thank you, Your Honor. And in People's Exhibit 7, Officer Cruto, that license plate there that's in the center of the picture, whose license plate did that come back registered to?
Mr. Michael Allen?
And in People's Exhibit 8, the next exhibit, looks like, what are we looking at in this picture here?
All right, so yeah, when I was taking pictures for this vehicle, there was a lot of items in the yard, so I was having a hard time being able to capture the entire trailer in the yard. So I tried to do what I could from behind, then I tried to make up for it by taking pictures from the front.
And in People's Exhibit 8 that we're looking at, on the kind of the bottom, the top of the bottom third, you can see that kind of diagonal black bar that is bracketed by what appears to be red plastic. What is that red plastic?
Which,
People's Exhibit 8.
8?
Yeah.
Oh, the red?
Actually, I'll just approach and I'm just going to
Okay.
point out. I'm not pointing at this.
Yeah.
Right here. Those things. So I'm going
And if you need to approach Mr. Lau to see what I'm looking at, because I'm going to look over the shoulder of the witness
Okay.
while you're pointing.
yeah, and I just demonstrated to Mr. Lau exactly what
Yeah.
I'm going to point to right here is this and that. And so I just gestured to People's Exhibit 8, the top of the bottom third, the diagonal bar, the two little red plastic things on either side of the picture. What are
Yes, so those are the taillights for the trailer.
And does the trailer have wheels?
Yes.
Let's pause for just a moment, because what I have labeled as Exhibit 8 in the system is not that. Mr. Reynolds.
Well, good thing I brought multiple copies of everything.
And we may have to have it. I'm gonna have to look through and see what we've got, but what we've got submitted as People's Exhibit 8. Looks like Ms. Keller, Nikki Keller put that in for us, but it does look to be different. And this is a picture of a white vehicle, if I'm, let me just double check. I'm clicking on it again to give it.
That's the right one, Your Honor.
There it is. Yeah, so I think when I clicked on it, it didn't open up correctly. So that it is the correct one. So thank you. Just a system error, I think, was going on there.
And so for Mr. Lau's benefit, we use an electronic court system. So everything, all of the exhibits that I've handed you today are in the electronic court system. And so that's what.
So I'm clicking on them and opening them up, and once they've been admitted, I'm looking at the exhibits.
No objection to that, Your Honor. I've received a PDF containing the new Ames format of the report plus photos. It's just that, so I'm not object. I am still a little bit dumbfounded what Prosecutor Reynolds is referring to. The two taillights or the little white-orange striping by the rear bumper. Sorry.
Why don't you just clarify with another
I'm
question?
just talking about the taillights.
Oh, the taillights, one on either end of the picture.
Okay.
It was a good picture taken,
Yes.
covering both taillights.
Okay.
And,
You can continue, Mr. Reynolds.
thank you. So Officer Cruto, just to confirm, the white box, looking at People's Exhibit 11, if you you go to find 11. The khaki colored, white colored rectangular object next to the skid steer, is that the
Forklift,
the forklift?
yes.
Is that the trailer in question here?
Yes.
And where is this trailer parked?
It is parked on the north side of the property, on the 4600 Sioux Drive side.
And is that a yard?
Affirmative, yes.
And so, did you issue a ticket for a violation of BRC 7623B, vehicle parked in yard?
Yes.
And at this time, Your Honor, I don't have any other questions for Officer Croto about this ticket.
Okay. Mr. Lau, do you have any questions for Officer Croto?
Yes, Your Honor, I do. Officer. So, okay, if I may just start from the beginning then. Of course, the ticket was issued on, this specific ticket was issued on October 11th. And so, as with the old version of T2, I could not find how it was initiated through your office for you to come down to that my location to issue the ticket. So that's.
I'm going to jump to relevance. How it was initiated is not relevant to the matter at hand.
What is the relevance to how it was initiated, as to whether or not there was a vehicle parked in a yard?
If the court wants me to reserve that to question Mr. Pelly, once again, it's a policy procedure. What brought about the officer coming down that day to issue several tickets? Your Honor.
So I understand what you're saying. So I'm going to allow the officer to testify briefly in response to that. So overrule the objection. It goes to the issue of whether there was selective enforcement, and I'll address that at the end of the trial. So you can answer the question. If you need to restate it, Mr. Lau, you can restate the question.
So the question was just why I was there that day. Is that correct?
What? Yeah, what initiated to come down that morning? Yes.
Yeah. So we had a hold on serving parking complaints over at the 290 Pawnee area in the middle of August, as I recall, and it was supposed to be lifted in the middle of September, and then it got pushed back another month into the middle of until the 11th of October. And so during this entire time, we had been accruing a large list of complaints that we had to serve. And so that was just serving the complaints that had been backlogged during that hold.
Any other questions?
No, yes, Your Honor. Yes, thank you for that answer. That is very consistent with what has been happening. Specifically on this ticket, of course, it's more because I do not know well enough when it's a vehicle in the side yard. I only know from another city department they are not supposed to come onto the property. So in this case, you came into the property, the north yard, and went, of course, around the trailer. Is that something that the city allows you as the enforcement officer to do so? If it is potentially a side yard violation?
Correct, yes.
Do you know the city codified thing referring to that?
I don't have it memorized. You're referring to the ordinance for vehicle in the yard.
Yeah.
I don't have it memorized word for word. But what I do know is that a vehicle in the yard must be 20 feet off from the sidewalk to be considered legally in your yard. And if that's not the case, then you would be in violation.
It should have been vehicles with an S.
So I only have the benefit of some information provided once again by the court administrator. So is that 76242 23A, 6B, 7620, pardon me, 7623B then. Is that,
So we have over 50 ordinances that we enforce, so I can't offhand
No.
tell you the definition of all the violations.
so yeah, based on.
Mr. Reynolds, do you want to just clarify what provision you're operating through?
7623B.
Okay, yes, because I saw the last entry in the subpoena prepared by the court, so yes. No further questions, Your Honor.
Anything else from the city?
No, Your Honor.
All right, you can step down, officer. Thank you. We may call you back again.
So that's it on that case, Your Honor.
All right, so Mr. Lau, on this case then, Mr. Reynolds has rested his case. If you'd like to testify about this particular incident, the alleged case for October 11th of 2024, a violation of section 7623B, you have the right to do that now. Would you like to testify on that, or do you want to call witnesses on that?
Your Honor, because Mr. Pelly
Can we get a straight answer?
has lots of duties, I would like to call him because once he's able to address certain issues, I believe also there's at least, from the defendant's perspective, there's no reason for him to stay further during court. So that way I don't have to keep calling him for each of the 6 trials.
All right, let's call Mr. Pelly, if you'll come forward, if you'll raise your right hand, sir. You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you, sir. Go ahead and have a seat. And if you'll start by just stating your full name and your occupation, Mr. Pelly, thank you.
It's Leo Pelly, Leo, last name P-E-L-L-E. I'm the parking enforcement supervisor, City of Boulder, Community Vitality Parking Services.
Thank you, sir. All right, go ahead.
Good afternoon, Mr. Pelly. Sorry, since I don't have the benefit of Prosecutor Reynolds introducing yourself in more details. So how long have you been with whether it's the City of Boulder or Boulder Parking or being a supervisor of Boulder Parking, please?
7 years this March.
As supervisor of parking?
Yes.
Thank you. So your department, of course, has a longer name that sometimes get abbreviated. So is it parking and access, or is it community vitality?
It's Community Vitality is the department, the division within the department is the parking access.
Okay, so that's a division underneath community vitality. Thank you. And I read from the website that your specific parking is responsible for downtown parking, parkades, neighborhood parking permits, and so forth. So you cover both neighborhood in general terms and also the downtown parking specific as well?
Yes.
Thank you. So, sorry, Your Honor. Now jumping to the specific general location of 290 Pawnee, or as prosecutor said, as well, 4600 or 4660 Sioux Drive. I have been informed by one of your parking officer that you have, because of the number of complaints that has been received, you have labeled it, either a hot zone or hot spot or something like that. and you direct him to enforce parking more vigorously, because there has been, sorry, that's my question.
So there are certain neighborhoods that do have a lot of complaints and areas that we have to give extra enforcement to because of the safety violations and concerns for the neighborhood.
In more general terms, I don't need to know specifically, how many different areas are we talking about here?
There's many.
Oh, sorry, many as in?
Many areas that have that extra enforcement at times, depending on the season.
And officer, is that complaint-based or are there other factors that are involved?
Usually complaint-based, yes.
So specifically, of course, regarding this ticket as well as other part of the other tickets that we'll be covering in the various trials, when was my specific area, because that's where all the tickets been issued to me, has been deemed that requires additional enforcement? When?
I would say probably since the summertime.
So roughly my June 2024 timeframe, as I've referenced earlier.
Sure.
And just so I'm clear, is that term hotspot, is that correct?
Yeah.
Be more of a focus zone, but I cannot recall that this location is on a focus zone.
Is focus zone an operational terminology, or is that a city?
Operational terminology, yes.
By your department?
Yes.
Okay, thank you. So now specifically, when this ticket was issued, of course, and now I have the benefit of more detailed information based on the new Ames report. But based on the earlier T2 system, of course, it would have provided quite a bit of information as well. What is the basis of whether the ticket has to be paid or dealt with or appealed either in a 14 or 15-day period? Because this specific ticket, when issued, the 15-day, you lose the right of the appeal after was printed on the front of the ticket. So would you please explain which part of the City of Boulder legal stuff allows the 14 days payment of 15 days appeal, and when the ticket is usually just placed somewhere on the vehicle, or if it's a trailer, either clipped to the license plate. In this specific case, the ticket was left with a paper clip clipped to the tongue of the vehicle and so forth. So what is the legal basis of the defendant? Well, any party cited would have no recourse to appeal after 15 days when the defendant, the person cited, may not have actually seen your ticket or may not actually be aware of it.
I'm going to object to relevance and compound question there.
In that case, I'll just limit it to the 14 or 15 days.
What is the question that you're asking for the 14 days?
What is the City of Boulder legal basis to not allow anybody cited, even though they may not have received personal service of the citation in any way or any knowledge of it? What is the legal basis? Sorry, once again, the city, whatever, bylaws and whatever, codified by council, whatever. Is there anything in 7623 or other related 762 something-ish type of thing that would support that the city government has mandated that, because the court has been using that, not only for me as a defendant in many situations, but also for other violators.
I'm gonna object to, this is now a testimony and also not a proper question for this witness. It's not a factual type question.
Calls for a legal conclusion from the witness that I'll sustain. But Greg, why don't you see if you can look and see if you can find the answer so we can move on from this. If you're looking through the code, and I'll look as well. But you're going to need to move on. This witness is not required to testify, nor does he have the ability to testify about the legal basis. That's a legal conclusion that a judge would have to make. What's the authority under the code for the issuance of the citation, and then the determination that you have 14 days to request a hearing or lose your right to contest. And that's somewhere in our code, but I'm not seeing it right off the bat.
Of course, Your Honor, I am pleased with the court's determination of that. May I ask a different question, Your Honor, while you are?
Yeah, you can go ahead.
Yeah.
I'm happy to hear.
So the court has, of course, has furnished me with certain citations after, and some roughly 30 of them, and some has been already listed as referred to collection. Of course, the court furnished me with that information. So what does that mean? Is there, when it's said on the listing that some of the tickets has been referred to collection, what actually does that mean?
Again, I'm gonna object to this not being a proper question for this witness. It's not relevant.
Sustained. It's not relevant. It certainly becomes something that you and I can discuss, but it's not part of this trial. The only issue for this trial is whether or not your vehicle was parked in the yard. That's the only issue that is relevant, and this witness doesn't have the
Your Honor,
does not have the capability of answering legal questions surrounding
once again,
collection matters.
if I may clarify, as the court records would show, the first time I was in traffic court, of course, I actually.
We're not going to go through that again. Mr. Lau, please.
So the fine amount.
Mr. Lau, one of us at a time.
Sorry.
Right.
He tried to raise his voice to keep going. Isn't that something?
I've just told you that this witness cannot answer that question. It calls for a legal conclusion. The question of why your vehicle is on the tow list or why your vehicle would be sent to collections are legal questions that I can answer for you outside of a trial. It's not relevant to the issue that's in front of me. This witness is here to testify about one thing, which is whether or not he would order a targeting or selective enforcement of your particular vehicle or your home. That's the only thing that you indicated he was going to testify about. He does not have the ability to testify about the code as to why or why not someone would be on a collection referral list. That's not within the scope of his testimony today. So you're going to need to narrow it to simply what he directed his staff to do with respect to your vehicle or your property or the property where you live.
Thank you, Your Honor. So I trust the court will look into the refer to collection issue because it does affect the fine and the
You and I can talk about that after these trials. We can definitely talk about it after these trials.
Thank you, Your Honor. Okay, so Mr. Perlio has already confirmed that my specific area was using his terminology, focus zone as determined by the department based on complaints and so forth. I really have no further questions for him.
Mr. Reynolds, any questions from you?
No, Your Honor, and I would ask the court, based off of Mr. Pilley's testimony here, to release him from his subpoena. I renew my same objection. Because I don't feel like the city does not believe that Mr. Lau has elicited testimony from Mr. Pelly to support any sort of improper prosecution argument. Mr. Pelly testified that there are many areas in the city that have these hotspots, and Mr. Lau has not elicited any testimony from Mr. Pelly that there's some sort of improper action that the city has been taking against Mr. Lau on the basis of race, ethnicity, age, or other sort of protected class status. And so based off Mr. Pelly's own testimony, his relevance for any future tickets here there is no relevance.
Okay, I appreciate that. So, and I'll allow you to make further comment and closing argument on the case. And
Your Honor, so.
Go ahead.
Yeah, I'm not sure about Prosecutor Reynolds saying, about Mr. Pelly being excused from the subpoena, because I've already said I've asked him all the questions I need to ask.
So you don't have a problem with him being excused from his subpoena?
But in an interesting way, thing that Prosecutor Reynolds brought up, if the targeting, and I'm not suggesting that is the parking, border parking, the department itself and so forth, but if it is based on race, and those criteria that actually Prosecutor Reynolds is that the municipal court jurisdiction, or is that a Boulder State district court jurisdiction, Your Honor?
What the issue that you raised is as to why you felt that Mr. Pelly's testimony would be relevant is that you indicated that he had targeted you. And I said it would be highly unlikely that there would be evidence provided, but I wanted to give you the benefit of the opportunity to see if you could provide some evidence from Mr. Pelly to indicate that he targeted you or selectively enforced you in violation of the state or U.S. Constitution. I have not heard any evidence surrounding that. Mr. Reynolds has made an argument saying that there hasn't been any evidence to support a selective prosecution claim. And it is based on protected class. The Constitution protects individuals from being selectively enforced. For example, someone who is of African-American descent being selectively enforced for various violations where others were not facing that same enforcement for a constitutionally impermissible reason. That's why I gave you the opportunity to offer Mr. Pelly's testimony. If you said you were done asking him questions,
yes,
when we hear closing argument, I'll get to that issue, but we'll address it then.
Yes, Your Honor, but I also want to clarify and apologize to Mr. Pelly if there is a need, and I feel that there may be implied need by a prosecutor. I have not tried to imply in any way that Mr. Pelly personally targeted me for anything, whatever. Sorry, Your Honor. Whatever the
constitutionally impermissible reason.
Yeah. So I, as you, at least even with my question, I have not even remotely implied that.
Okay.
I just simply do not understand the process and procedure that leads to my tremendous number of tickets and warnings that I wish to have that clarified.
Okay.
And if it appears that I have implied that Mr. Pelly has taken a unprofessional conduct to label that as a focus zone, that was not intended in any way.
Okay.
So.
Good enough. You could step down.
Thank you.
Pelly. If you'll stay for just a few minutes, because we're gonna have closing arguments here in a few minutes. We'll see if we have any testimony from Mr. Lau. Mr. Lau, did you want to offer any testimony in connection with this particular ticket, the October 11th, 2024 ticket, which alleges a vehicle was parked in the yard?
No, Your Honor.
All right. So closing argument. Did you want to give a closing argument, Mr. Reynolds?
Thank you, Your Honor. The city believes it's proved beyond a reasonable doubt that there was a vehicle that was parked in this yard that was registered to Mr. Lau in violation of 7623B, which prohibits any vehicle from being parked in a required yard. The required yard essentially means the setback area either on the front of the house, front of the building, or the side of the building. And as Mr. Cruto testified, that it was on the side of 290 Pawnee, and that it was on a trailer with stoplights, and that it was on wheels, so it meets the definition of vehicle per the code. And then I would just reiterate that Mr. Pelly's testimony did not give rise to anything that demonstrates that anything improper is happening with these hearings with Mr. Lau, that there just wasn't any testimony that supports any sort of improper selective prosecution.
Okay, thank you for that, Mr. Reynolds. Closing argument from you, Mr. Lau.
None, Your Honor.
All right. So the allegation in this case is that on October 11th of 2024, the defendant was the owner or registered owner of a vehicle that was parked upon private property within any required yard abutting a street. The testimony provided by Parking Ambassador Croteau was that on this particular date, he was at that location. He took photographs of the location that shows in exhibits 7 through 15. A vehicle that was registered to Mr. Lau that was parked upon a required yard abutting a street. That evidence has not been controverted in any way. The court's convinced beyond a reasonable doubt that there was a violation and will find the defendant guilty. With respect to the allegation that there was targeted enforcement, the only way this would be relevant is if there were evidence to suggest that there was a constitutionally impermissible purpose in the enforcement mechanism utilized by parking services on June 11th. And Mr. Pelley simply testified that there are focus zones that are complaint driven, that if there are a significant number of complaints, that an area can be in a focus zone, and that's where enforcement might occur more regularly than others. There's nothing impermissible about that. And so I'm going to find that the allegation that Mr. Pelley had some information that he could share in these other cases, I don't see any purpose in him being required to testify in any other case, because the testimony that he gave just a moment ago would be the same. And I think that's what you were suggesting, is that you don't need him any further beyond this particular trial. So Mr. Pelley's free to go. You can also remain in the courtroom if you choose to do so, but I have found the defendant guilty of the citation that ends in 3985. And so let's turn to the next, which is, I believe it's 3988.
Oh my goodness.
And that will be the next citation that ends, and that's also from October 11th of 2024. Mr. Reynolds, did you have something that you wanted to suggest on that one?
3988, just that we're ready to go on that.
Okay.
Not yet.
Any opening statement from the city on that one?
No, Your Honor.
And any opening statement from you, Mr. Lau, on that ticket?
The only thing regarding this specific ticket, and of course the information's furnished by the city, there is a second page that account tickets, which I have not seen before, and based on some whatever timestamp and lots of customer judicial order PDF, and also October 11th, 10th, 11:23 a.m. to 1:40 p.m. and there's probably about 20 plus entries. Your Honor, I have no idea what these things are.
I can't take a nap. I gotta watch it with y'all. Y'all can take naps. I'm the only one. I'm the one being shown. I can't take a nap. But listening to him, yes, it make you want to go to sleep. Good gracious.
I've asked earlier for prosecutor but that was both emailed to me and printed by the prosecutor.
What are you asking about these?
What is that? Sorry, Your Honor. It does show the ticket number on top, but what are these entries? Are they a computer glitch? It's all generated the same day within several hours of each other? Sorry, Greg, I should have showed you. I just have no idea what that is.
Oh, thank you, Tess. I appreciate that for the coffee. And yes, hit the like, everybody, when you get a chance. But I appreciate your super chat. And yes, I will get some.
Yeah, I'm pulling that vehicle up. I think those are, from what I can tell, what he's referring to are blank judicial orders that may have been created somehow through the Ames, T2 Ames.
But there's nothing, no
There's
content for any of
nothing on
this.
them. I can click on one or two of them to show you.
Why don't you show Mr. Lau right there?
Yeah, please, because
So I'll just show you this one here.
Yeah, okay. Can you show one of the picture?
So
maybe
here's
just-
one of the picture ones.
That's fine.
Okay.
Uh-huh.
And then this is just a document.
And what?
This
Because
is the first one. This is just a blank judicial order that's created, likely because, well, I'm not going to speculate why it was created, because it's possible it was when we switched over from T2 to Ames.
But it cannot be a judicial order.
There's
It's
nothing
not
on it.
being-
There's blank, and
Yeah,
there's nothing we
okay,
can't
so,
create it.
okay,
There's nothing on it.
okay. Thank you, Your Honor.
Okay.
That explains.
Are you ready to proceed in case number, ends in 3988? This is an allegation that you violated section 7624B of the Boulder Revised Code. And I think we've had one of these before, but I'll remind you, this is no camper, motorhome, or trailer shall be parked on any city street except when located directly on street frontage in front of the single-family or multifamily dwelling of the vehicle's registered owner for a consecutive period of 48 hours or less. So I'm assuming this is a 7624B1 case. Is that correct, Mr. Reynolds?
Yes.
All right. So, Mr. Lau, that's what this case is about from October 11th of 2024.
Thank you, Your Honor. Ticket, the last four, 3988, it shows the violation code being 7624B-40.
I think that's it's not necessarily a -40, that's just an underscore 40, and it doesn't have a relation to the code section. It's 7624B, and Mr. Reynolds has identified that the subsection is B1.
I have
Your
no
Honor,
clue.
underscore 440 aside, I also have not in reference with documents prepared by the court that it is 7624B1. Because
It's indicated as 7624B, and then Mr. Reynolds orally confirmed that that's under subsection 1 of 7624B. So the allegation is the one that you had a camper or a trailer that was parked for longer than 48 consecutive hours in front of your house. So that's the allegation. I don't think it requires much further discussion.
in most situations, it would not, but I do not see in any of this information that the trailer was actually there continuously for 40 plus hours.
That's what they're going to have to prove.
And in fact, Your Honor, you have ruled much on a separate trial that the 48 hours or ban from city street is not a valid thing.
Yes, that's correct, but let's hear the evidence. We haven't heard the evidence yet.
Please, yes, Your Honor.
Mr. Reynolds, your first witness.
Thank you. Officer Couteau, yes.
Mr. Costello, if you'll come forward again, I'll just remind you, you're still under oath, sir.
Yes. All right, good afternoon, Officer Couteau. I'd ask the court to take judicial notice of his position, his duties, how long he's worked there, his name, all of that.
Mr. Lau, do you have any objection to me taking judicial notice of what was testified in the earlier trial? Okay, I will take judicial notice of that.
So Officer Couteau, we're looking at, again, October the 11th, a little bit later, 11:23 in the morning. You issued some more tickets that day,
Yes.
and I'm going to approach with what's been marked as People's Exhibits 16 through 22, copies of which have been furnished to Mr. Lau. And Officer Couteau, can you just go ahead and take a look? All right, do you recognize those pictures?
Yes.
Did you take them?
I did. Yes.
Are they a fair and accurate representation of the scene as it appeared at that day at that time at 290 Pawnee?
Yes.
And is 290 Pawnee in the city of Boulder, state of Colorado?
Yes.
At this time, I move to admit People's Exhibits 16 through 22.
All right, Mr. Lau, do you want to take a moment to look at those exhibits and determine if you have an objection to the admission of any of those exhibits?
No objection, Your Honor.
All right, exhibits 16 through 22 will be admitted.
So, Officer Couteau, what vehicle are we looking at in these exhibits?
This is gonna be the large trailer, that Mr. Lau owns.
And how do you know it's Mr. Lau's?
It came back, clearing it through PD.
The DMV registration of the license plate,
Oh, yeah,
and that came back to Mr. Lau?
correct, yeah.
I see. And what is the violation here that we're talking about for this ticket?
So yeah, this is gonna be our camper RV trailer. It was put on a camper trailer watch. And so what that means is that when the vehicle is on that watch, it's got 48 hours. If it's still there, then it'll be cited.
And you cited it on October the 11th of last year at 11:23 for being parked on a city street longer than 48 hours. Is that accurate?
Correct, yes.
And how long had it been parked on the street? What's the information that you have?
Well, the last time we had seen it was on August 16th, and also on August 19th. And that's approximately when we were told to hold off on citing vehicles in that location per the court proceedings that were happening in that location.
August 19th, and that was of 2024?
Yes, yeah.
And do you have any reason to believe that it had been moved off of a city street between October 11th, 2024 and August 19th of 2024?
No.
And I don't have any other questions.
Mr. Lau, questions for Officer Couteau?
Yes, Your Honor, thank you.
It takes them so long to get something out. And as someone mentioned in the chat, if we're going to go through all 100 tonight, grab your pillows because you're going to fall asleep.
Of course, that definitely is my trailer, and I've been loading things.
Objection, this is testimony.
Sustained. You can just ask him questions right now.
How can you ascertain that it has not moved at all since August? There are definitely in one of the photos in exhibit 18, is it 18? 18, it does show chalk mark on the tires. So you are testifying that those were made in August of 2024-ish, and they remain that way on October 11th that you issued the tickets?
No.
The ticket.
So the chalk was placed on there on the 11th of October, the day that I arrived to give this citation. On the 19th of August, the vehicle was same street, same 100 block, was just right across the street.
Same, but right across the street.
Correct.
So it's not what you said earlier, that it has not moved at all since August. You just testified that earlier.
So if you perceive that, that would be incorrect. What I said, it was, as my knowledge, it was on the city street. So per subsection C, a vehicle cannot be removed onto another city street for that defense of that vehicle. So the vehicle can move, but it can't be, it has to be on private property or outside the city.
Your Honor, I thought we have addressed that in an earlier trial.
Objection, that's not a question.
I'm asking the judge. But, so.
So I've addressed the implications of section 7624 previously. And I'm going to try to make sure it's clear here again. And I think I did this in writing.
Yes, you did, Your Honor.
But
Because
7624B basically states that you can't park your vehicle on any city street unless, and then it gives an exception, and it says that you can park it in front of your single family or multifamily dwelling of the registered owner for a consecutive period of 48 hours or less. So you're not allowed to park it anywhere except along or abutting your own property where you are a resident, and only for 48 hours. Subsection C says it shall not be a defense to this section that the camper, motorhome, or trailer has been moved to a different location on any city street, which means if you park a trailer or a camper in front of your residence, you have 48 hours to have that camper there. You can't move it to another city street during that 48-hour period and say, well, gee, I'm no longer there, because that's not an exception to the rule. It simply says that it can only be there for 48 hours, and you can't move it to another city street to avoid the implication of that 48-hour subsection. What I was indicating in that last trial, just to make it clear for everybody, is that it doesn't mean that forever a vehicle can't be parked in front of someone's residence. So if you park something in front of your residence on August 11th, and you have it there for less than 48 hours, and then you move it somewhere else, not on a city street, you move it somewhere else, and then on October 11th, 2 months later, it's parked there again, it can be there for 48 hours. So the city has to prove that the vehicle, in this particular circumstance, was parked for more than 48 hours on a city street, whether it's parked at your residence or anywhere else. But on this particular case, they've alleged that the violation occurred during the 48 hours preceding October 11th, that for 48 straight hours, that vehicle was parked on a city street. That's what they have to prove. Whether they will or not, I don't know. But the testimony I have so far is that the officer came on October 11th and issued a ticket, and that he was aware that in August, that same vehicle was parked on a city street. There may be an argument that's raised by the prosecutor that I can infer that during that period, the vehicle was continuously parked and such that it would, in the 48 hours prior to October 11th, that it was parked in that location. I don't know that to be true yet. I'll have to hear arguments.
Officer, you said you put those chalk mark on the tires on October 11th.
Correct, yes.
Then it's just your very good memory that it was in the vicinity in August that you deduce that it's been there for 48 hours without proof.
So per the photos for citation 2421-470-3237, it documents your trailer right across the street at the same location. And I was basing it based upon that.
Sorry, you kept using across the street.
Yes, correct. It's the same 100 block, same street. It was just moved it was in front of the church, right by that property there. And it was just moved to butting alongside of 290 Pawnee.
And you're referencing the August 11th, or the August...
the 19th was the last time.
August 19th.
Over there, correct.
Okay. And just for clarity, between August 19th and October 11th, you did not observe that vehicle?
Correct, yeah, we were told to hold off on enforcement of that location.
Okay. All right. So what he testified to is on August 19th, it was parked across the street, and on October 11th, it was parked in front of your house. That's what he's testified to.
And in between that time, it was parked on actually the side yard because you couldn't.
You can't testify right now. You'll have a chance to testify, but you can just ask him questions, and he, based on my questions or your own.
No further questions for him, Your Honor.
Anything else from you, Mr. Reynolds?
Just one brief follow-up. Officer Crito, how many times have you been out to 290 Pawnee?
Too many to count.
And is there any place at 290 Pawnee on the private property there that this trailer would legally be able to be parked on that private property, given its length?
If there were no items in the yard or the driveway, I would say yes.
Have you ever been there when there haven't been items in the yard or driveway?
Nick, no.
Okay, so in your experiences, have you ever seen a 290 Pawnee in a state in which it would allow that trailer to be parked on that private property?
No.
That's all I have.
Okay. Any other questions based on those questions, Mr. Lau?
Yes, Your Honor. You have never observed the side yard or part of the driveway being let's say vacant or empty with the possibility of a trailer of that size being able to park there? That is, you are more or less testifying that between August and October 11th, you are certain, because you issued a ticket based on the 48 hours, that one time it was on the other side of the street, but when you were back on the 11th, that it was on the other side of the street, that there is no possibility it could have been somewhere else.
Not to my observation.
But your observation is not continuous.
It doesn't have to be.
Your observation is not even covering the 48 hours.
It didn't. It started on the 16th of August.
Your Honor, with no additional photo evidence with valid timestamp, I don't know what other questions I can ask the officer.
Okay. You can step down, officer.
Got rid
Any
of
other
that.
witnesses for
No,
the?
Your Honor.
All right, Mr. Lau, the people have rested on this case. Do you want to offer any testimony or evidence?
Your Honor, once again, it's a very, not questioning the professional conduct of the officer, but it's a very subjective thing. But on August.
You'll have a chance to give closing argument. The question is do you want to testify or offer witnesses on this particular incident? And then we'll have closing argument after that. If you decide to testify, we'll do your testimony first. And if you don't want to testify and you just want to argue, because you do have the right to argue whether or not they've proved the case. That's still up in the air at this point.
I can argue based with the closing, right?
That's right.
The closing, yes, I will defer to that.
So you don't want to offer any testimony, you just want to offer a closing argument.
For the sake of time, I just want to move on.
All right. Closing argument then, Mr. Reynolds.
Thank you, Your Honor. The people believe they've proven beyond a reasonable doubt that this trailer was parked in violation of the code section 7624B, all-night parking of the trailer prohibited, in particular, the 48-hour rule. Officer Cruchu testified that he's been out to 290 Pawnee many times and has not, and has observed this vehicle in August twice, and then in October, just about 6 weeks later, still parked on the city street. And the court has no evidence that it was ever moved from a city street. The only evidence that the court has is that the vehicle was on the city street in August and then was on the city street in October. Furthermore, Officer Cruchu testified that he's been out to 290 Pawnee too many times to count, and he's never seen 290 Pawnee not have objects either in the driveway or on the yard to allow a trailer of this size to be parked on that private property. And so because the court, the only evidence that it has is that for much, much longer than 48 hours, this trailer was on a city street, we've proven beyond a reasonable doubt that it was parked in violation of this code provision.
Okay, thank you for that, Mr. Reynolds. Mr. Lau, you want to make a closing argument?
Yes, Your Honor. The city definition of beyond reasonable doubt is more like a wonderful speculation when in fact the officer already testified it was on one side of the street, then it was on the other side of the street during these. The city is trying to infer that it could not have possibly gone on to the church parking lot. It could not have possibly gone on to the property side yards or driveway of 290, but without any evidence supporting that it's been there for 40 hours prior at the same location prior to the issuance of the ticket. And the officer already testified the chalk mark was put on after the ticket or during the ticket being issued. So the leap of presumptive whatever is I don't think that is valid in any case. That specific trailer.
Don't tell me any
Actually-
facts. You can't tell me any facts because you aren't under oath. You can just comment on the facts that I've heard. So far you've done a good job of commenting on the evidence that I've received. So you can only comment on the evidence that I've received.
On the evidence you've received, there are 3 officers, well, 1 supervisor, and they truly have seen that trailer even in the church's parking lot, which is not city street. So the presumption that the day it was ticketed, it has been there in exactly that 48 hours prior to that.
Hold on. That's a good idea. But you know what happened? His trailer will end up in it some kind of way.
Cannot be substantiated. Now, if they mark it and there is a further case with specifically on this trailer on the 14th of October, that they did refer to the chalk mark hasn't been disturbed or whatever, that may be a more valid argument. But the presumption of, once again, in this case, the presumption of guilt by the defendant based on no true documented proof that it was even there 48 hours prior to that is definitely, I believe the city prosecutor has failed to make that point more convincing.
Thank you for that, Mr. Lau. Mr. Reynolds made a fairly compelling argument that since the vehicle was parked on August 19th on the same street and then was seen again by the officer on October 11th, that the court could presume that the vehicle was parked or that trailer was parked in that location on a city street for the period of 48 hours prior to the issuance of the summons. But with this, I actually agree with the argument that was raised by Mr. Lau, which is that there isn't enough evidence to convince me beyond a reasonable doubt that that trailer was parked for 48 hours on a city street, whether it was in front of the defendant's residence or not, that was parked on in front of the defendant's residence for 48 hours preceding October 11th of 2024. And there may have been some, I think part of what occurred was the fact that the court had a different perception of how 7624C applies, and that may have dictated why the officer didn't feel the need to actually go out to that property for 2 days prior and make sure that the vehicle was still there 2 days after or 48 hours after. That may change, obviously, now that the court has given its view of how 7624C should apply. But in this case, there just isn't ample evidence for me to make that logical leap to find beyond a reasonable doubt that that trailer was parked there for 48 hours prior to the issuance of the summons on October 11th. So I'm going to find the defendant not guilty of that charge.
Huh? Oh, I know y'all do not like that. And y'all just voted guilty? Let's see. Almost 100%. Unless some people click no as soon as he said not guilty. Trish, thank you for the super chat. Like and subscribe or be found in contempt, huh? So go like. If you're not subscribed, subscribe. Or you're going to be found in contempt here. That's what Trish said. She mean it. She stand by it. All right. Let's see what's next.
And we can go on, Mr. Reynolds. I don't know what the 3990 would be the next citation. Are we ready to proceed on that
I'm
one?
ready, Your Honor.
All right, so let's go to case ticket number 3990.
Can we recall Officer Kuto? Same thing, right?
Yeah, you could jump in.
Kuto, okay, yeah, not Kuto, Kuto. Good. How do you say Kuto? Please.
I just call him officer.
I'm starting to feel like we're actually stuck in a loop in this video and that maybe the ticket numbers are the same, but we're so confused at this point, we don't know what's going on. Is this video playing over and over again? I'm like, man, this is crazy.
And this is a valid license plate ticket issued also on October 11th of 2024, a violation of section 7623 of the Boulder Revised Code. So officer, just still remind you you're under oath. If you go ahead and have a seat. And Mr. Reynolds, whenever you're ready.
Your Honor, I'd ask the court to take judicial notice of the intro testimony that Officer Cruto gave in the first trial that we had in terms of his name, his position, his duties, how long he's worked here and all of that.
Any objection to me taking judicial notice of that prior testimony?
No objection, Your Honor.
All right, we'll take judicial notice of that testimony. Go ahead, Mr. Reynolds.
Thank you. Officer Cruto, on October the 11th, about 11:37, did you write another ticket?
Yes,
And was this at 290 Pawnee, City of Boulder, State of Colorado?
yes,
And was this for license ending in 9675?
yes.
And is that, who is the registered owner of that vehicle?
It'd be Mr. Michael Lau.
And now I'm going to approach with what's been marked as People's Exhibits 1 through 6, copies of which have also been furnished to Mr. Lau, and I'm just going to approach the officer. More pictures up here. Okay, here we go. Officer Cruto, can you just take a look at those exhibits real quick and then look up when you're done? Thank you. And do you recognize those pictures?
Yes.
How is it that you recognize them?
They were photos from a citation that I gave to a white pickup truck with expired plates.
And was the citation in this case, was it for having expired tags?
Yes,
And so would that be the Boulder Revised Code, section 7623?
yes,
And you were giving this, you were out there on October the 11th of last year, 2024. When did the plates expire?
they had expired August 8th of 2024.
And is that clearly demonstrated or shown in People's Exhibit number 3?
Oh, you don't want to watch 99 Hearings, Trish? Of course not. I'm not going to sit here 99 times for this. We're going through the case of Mr. Lau. This is his next hearing. I'm just trying to get through it. But no, it's not 99 hearings in here. I would not do that. We wouldn't even finish this tonight. That would be ridiculous. People would be probably upset with me if we did that.
Yes,
Did you look to make sure that there wasn't like the current plate or anything like that on the car? Did you see any current tags?
there was no, that was the only license plate that was visible.
At this time, I don't have any other questions for Officer Cruto.
All right. Mr. Lau, any questions for Officer Cruto?
No questions, Your Honor.
All right, officer, you can step down. Thank you. Did you move to admit exhibits 1 through 6? Mr.
I'm
Reynolds?
sorry, I did.
Did you have any objection to those exhibits? Mr. Lau?
No, Your Honor.
Exhibits 1.
See, that's what I'm talking about right there, Fanta. We're in it to win it at this point. So I think it's 98 of them. No, I'm just kidding.
1 through 6 will be admitted, just to make it clear.
I believe that I did.
Well, you've done it now.
Okay. Just,
Sometimes we're thinking about too many things at once.
yes, that is the case. I don't have any other evidence or witnesses.
Okay. Mr. Lau, it's now your opportunity, if you choose to put on testimony on this particular incident, October 11th, with a invalid license plate, an expired license plate is the allegation. Did you want to testify or offer evidence on that?
No, I am ready for the closing.
Okay, closing argument then, Mr. Reynolds.
Your Honor, the people believe that they've proven beyond a reasonable doubt that the vehicle owned by Mr. Lau was displaying expired tags in violation of 7623. Officer Cruto's testimony was clear to that effect, and we would ask the court to uphold this ticket.
Closing argument from you, Mr. Lau.
I actually concur with the city's position.
Go on.
Thank you.
I think the evidence is overwhelming in this particular case that there was a vehicle that was parked, it's registered to Mr. Lau, that the license expired on August 8th of 2024, so I will find the defendant guilty of that violation. And then we can turn to the next case, which would be case number ends in 4076, and that's from looks like October 14th of 2024. So we'll turn to that now.
And Your Honor, I'm not intending on actually giving the court any of this paper, since I've already uploaded all the exhibits.
Yeah, I don't need you to. Yeah, you've done what you need to do. Thank you.
All right, Officer Cruto, if you wouldn't mind.
Give me a moment. I'll pull that ticket up, 4076, and I can tell this is an alleged violation of subsection.
The officers should just stayed up there.
7620 of the Boulder Revised Code, and I'm going to just make sure I pull that up so I can tell the defendant what that provision says. Section 7620 states, no vehicle shall be parked upon any street for more than 72 hours without being moved or for the principal purpose of storage for more than 72 hours. And then in subsection B says, proof that the vehicle's odometer shows movement of no more than 0.2 of a mile during a period of at least 72 hours shall constitute prima facie evidence of a violation of this section. That's not the only way it can be proved, but that's certainly establishes a prima facie case in the city. And that allegedly occurred on October 14th of 2024. And also, I'll just remind you, you're still under oath. You can go and have a seat.
Good afternoon again, Officer Cruto. Your Honor, I'd ask the court to take judicial notice of all of his previous testimony in terms of his name, his job, his duties, how long he's worked for the city.
Any objection to me taking judicial notice of the prior testimony?
None whatsoever.
All right, we'll take judicial notice of that testimony. Go ahead, Mr. Reynolds.
Thank you. So, Officer Cruto, we're talking now about October the 14th of last year. Did you find yourself at 290 Pawnee, City of Boulder, State of Colorado that day?
Yes,
Were you doing some more parking enforcement?
I was providing a checkup.
Okay. And what checkup were you providing?
I was providing a checkup for abandoned vehicles that had gotten started on the 11th in that location.
When you say gotten started, what do you mean by gotten started?
So we had, the court order was lifted as far as allowing parking services to serve parking complaints that we had in queue. So the 11th, we came out to serve them. And then the 14th is when the checkup would have occurred or did occur for abandonment for the checkup.
And so on the 11th, which is 3 days previous to this time, you were there before noon, correct?
Correct.
And so the checkups that you did, that include chalking tires?
Yes,
And so on the 11th of October, did you chalk tires to a vehicle with the license plate of the last four 8784?
yes,
And so you chalked those tires before noon on the 11th?
yes.
I'm going to approach with what's been marked as People's Exhibits 23 through 30, copies of which have been furnished to Mr. Lau. I'm going to hand them to Officer Cruto. Officer Cruto, can you look at these pictures and then just look up when you're done, please? Do you recognize those pictures?
Yes.
How is it that you recognize?
All right. Who was that? Really? You knew that right off the bat? I didn't want to, just long enough. Maybe this will break up the momentum for a minute, but yeah, that's what I have at the moment. I just kind of started messing with those a little while back. So, it'll keep you focused on this.
These would be the pictures for my citation.
Did you take them?
I did, yes.
And did they appear to be a fair and accurate representation of the vehicle as it appeared on October the 14th of last year?
Yes.
I move to admit People's Exhibits 23 through 30.
Mr. Lau, do you have any objections to any of those exhibits?
No objection, Your Honor.
Okay, exhibits 23 through 30 will be admitted.
The vehicle that's depicted in those photographs, Officer Cruto, who owns that, or who owned the vehicle at least on October the 14th?
Mr. Michael Lau.
Hey, see this up on the screen right here? I'll let the chat address you with that one.
And when we're looking at the pictures, I want to draw your attention to People's Exhibit 25. People's Exhibit 25 depicts part of a vehicle. There's some rust there and a large tire, and on that tire there seems to be a yellow mark on the tire, and there also seems to be a yellow mark on the asphalt just below the tire. Can you tell us what are those yellow markings?
Yeah, so typically we'll do two things to prove that a vehicle has moved or not when it's under a abandonment watch. The two tools that we use is we use physical chalk, which should be that yellow line on the tire. And when we do that, sometimes the chalk will go onto the street. Not a whole lot, but then the other thing that we use as well is what's considered a digital chalk. And the idea of that is to say where a valve stem was when we observed the vehicle originally, and it would correspond with the pictures in the citation.
And so, drawing your attention to People's Exhibit 28, essentially that is a picture of a tire on the vehicle.
Yes.
And you said, where is the valve stem located in this picture?
So this one is going to be number 28. The valve stem is located at the very top. Looks like a sticker on the wheel. But yeah, that would be the 12 o'clock location.
And so for valve stems, you mentioned 12 o'clock location. Do you use like the faces, the face of a clock when referencing valve stems?
Yes.
Okay. And so on the 14th, did you give this vehicle a ticket for being parked for more than 72 hours on a city street?
Yes.
Why did you give it that ticket?
Because per my checkup, chocks were still visible and the valve stems were still unmoved.
And the chalk still being visible, what does that tell you?
That means that the vehicle hasn't moved at all.
And what makes you say that?
Because the chalk remained undisturbed along with the digital, or the valve's placement on the wheel28 remains consistent.
And so on People's Exhibit 28 that we just looked at, you said the valve stem was at the 12 o'clock position?
Yeah.
Was it that tire's valve stem at the 12 o'clock position on October the 11th?
Yes.
And then similarly, on I believe it's People's Exhibit 26. This depicts a different tire.
Correct, yes.
And where is the valve stem in this picture?
This would be approximately in the 630 location.
So kind of on the bottom left-hand side of the tire.
Correct, yes.
And so is that valve stem in the same position on October the 11th?
Yes.
And so the chalk and the valve stems were the same on both the 11th and the 14th.
Yes.
I don't have any other questions for Officer Cruto on this ticket.
All right, thank you. Any cross-examine of Officer Croto on this one, Mr. Lau?
Yes, Your Honor. You stated that the chalk marks were put on October 11th.
Correct, yes.
So the pictures shown here, is it from October 11th? The exhibits already submitted, is it from October 11th or October 14th?
These would be from the 14th.
When you put the chalk marks on, you took no photo record of it.
Oh, so the pictures are, so exhibits 23 through 30 is the evidence that it did not move. The chocks still remained on the tires per my checkup, and the valve stems were all in the same location per my checkup.
Sorry, 23 was taken on which date? 11th or 14th?
So again, all these pictures for this was on the 14th.
The pictures were on the 14th.
Yeah.
And you testified you actually chalk it on the 11th, but you are offering the prosecutor and you not offering any photo evidence. There are several here, all on the 14th, but none on the 11th.
So ticket number 24214703982 has all the photographic evidence from October 11th,
So
when the checkup started.
sorry, what are you referring?
That's a lot of pennies if somebody did that. I hope they come back to retrieve them at the end of the day or something.
to? I don't know what you're referring to. Which one? Which ticket?
The last four numbers is 3982. I don't think it was a request to be challenged. So it would have been a warning citation that was given that day.
But let me just clarify, did you take any photographs on October 11th?
Oh yeah, yes. I have them here.
You have them here.
I do, yeah.
Good. Well, Your Honor, may we all see it? Because I am questioning the.
I understand what you're getting at,
Yes,
yeah.
thank you.
So they haven't been disclosed, is that correct, Mr. Reynolds? They weren't part of the original disclosures?
Photographs from the 11th on this case were not part of discovery. That is correct.
So.
Yeah, I have no idea.
If you don't have an objection, then, and if Mr. Reynolds doesn't have an objection, right now I'm in a place where the only disclosures that were made were these exhibits that were just recently admitted.
Yes. And that.
If the parties want to agree that they can be disclosed and or that they can be referenced here, I don't have a problem with it. But if either of you have an objection, then I'll be left with just the officer's testimony as to what he did on October 11th. And you can continue to examine him on that. But let's turn to first Mr. Reynolds. Any objection to those?
I'm fine with Officer Cruto taking a second to give Mr. Lau those pictures that Officer Cruto has, but the city's comfortable with the evidence that it's presented.
So I guess the question is when you say you have them, is it on a phone or where do you have them? Physically?
I had them printed out in case it was requested to have them.
And where are they?
I have them with my things.
Why don't you go ahead and step down and grab them, and then we can, what I'll do is have Mr. Reynolds mark them as additional exhibits and then give them to Greg so we can make them, it'll be a bit of a step because we have exhibits through 45, but we can do 46 through whatever you think is appropriate. Maybe one picture, it may be several, I don't know. You have exhibit stickers that you can put on.
I don't, do you have the exhibit stamp?
Oh, that's right, we do stamps now. Yes. So you could,
I mean, Your Honor, the city's okay with not making these additional exhibits. I'm happy to just give Mr. Lau this.
okay, and then if Mr. Lau wants to make them exhibits and cross-examine on that, you can. So he's not required. He doesn't have to put on evidence other than what he's already put on. In your case, but if you want to,
But it was not provided to me
he's not,
prior to trial, not even provided to me at the beginning of the trial, and now
it's up to you.
I have a leap of faith that if I want to even look at it, does that mean that it would be submitted as evidence?
No, if you want to just look at it and decide, it's going to be entirely up to you whether you want to submit it as evidence.
I'll look at it and decide, Your Honor.
There you go.
Just to clarify, you actually provided me 3 photos from the 11th.
I took the most appropriate
Yeah.
pictures that would give them most.
Why don't you come forward and show them what you're talking about, the ones that you've done.
Because.
And Mr. Reynolds, of course, you're free to come forward.
Sorry, yeah. Thank you. So these are the ones, okay, back 14 first then. These are the ones already submitted, okay, right?
Yes.
Okay. So these are the ones that hasn't been submitted yet, but I'm reviewing them. So these are all on the 11th. And the timestamp is all based on your handwriting. These are also based on your handwriting. how come it's not like the ones in the file that has the little ticket number and digital thing on top, especially even on the 14th?
So the reason for that is because I just kind of wanted to get a couple pictures to kind of paint the reason why I was there.
Sorry, yeah.
We haven't been admitted, haven't been admitted yet. so-
No, I just want to.
So I guess, yeah, so one of them was the warning was the 11th. And then, so how that always works is the watch starts with the warning and everything is documented. And then 3 days later, which is the citation we're talking about right now, is when I gave the real citation. And so I only selected the pictures that were in the warning citation for the 11th, and then the pictures for the violation for the 14th. I picked the most appropriate pictures for my evidence.
Okay.
And that ticket does exist. You could always look at the file as well. I guess the court's fine to look at that, but I want to see the ticket numbers on the top as well, if you're curious what the number was when the watch had occurred.
So Mr. Lau, the question for you is those three photographs that Mr. Reynolds provided to you, are you wanting to have them marked as defendant's exhibits and introduced or not?
Your Honor, the fact that they were not consistent with the quality and the validity of the photos that has been submitted to court already, and the fact that it's only upon my questioning of the of when it was chalked that these are only being provided now, but in a more casual handwritten format. I do not see how they can be valid.
So you don't want to introduce them?
Introduce them?
You don't want me to consider those photographs?
No, Your Honor.
Okay.
Because
Fair enough.
The one on the 14th definitely are more closer to what has been I have already agreed to have them omitted, whereas the ones on the 11th are just, even the quality of the photos looks drastically different. So
That's your choice. You can offer them for admission or not. Mr. Reynolds says he's not going to offer them.
Not offering the photos submitted from the prosecutor's side for admission.
Okay.
Sorry.
All right. You can continue. You have any other questions for Officer Croteau?
So just tidying up on the photos that has already been submitted, 22 through 30, it does show that, of course, you have taken. It does show the blue truck, and then actually it also shows different vehicle, a vehicle both in front and behind it. So just based on once again, you have testified, you chalked them the morning of the 11th when you issue out the tickets. But of course, you only chalked this one because the temp tag was valid, the plate was valid still based on the expiration date and so forth. But you are testifying, you chalked them. And the pictures, of course, hasn't been omitted or will not be omitted. So that's the question I have. That's all the question I have for you.
Oh,
Any other questions, Mr. Reynolds?
No, Your Honor.
All right, you can step down, officer. Thank you. Any evidence that you'd like to offer, Mr. Lau? Any testimony or evidence that you'd like to offer on this
No, I'd
case?
like to proceed to closing.
Closing argument then, Mr. Reynolds.
Thank you. The city believes it's proven beyond a reasonable doubt that this vehicle was parked for longer than 72 hours as prohibited by 7620. Officer Cruto's testimony was clear that on October the 11th, he came out and he started the vehicle, which is a term of art in parking services, which means observing placement of valve stems and application of chalk on the tires. He testified that on the 14th, he arrived he was there in the mid-afternoon, observed the valve stems and the chalk, and they indicated that the vehicle had not moved. And so we would ask the court to uphold this today.
Thank you, Mr. Reynolds. Any closing argument from you, Mr. Lau?
Yes, Your Honor. The defendant definitely absolutely not disputing the quality nor the validity of the photos, of Exhibit 23 through 30. There is simply no irrefutable evidence provided by the city that that specific vehicle was there for a total of 72 hours prior to this ticket being issued. The suggestion of a warning ticket or the suggestion of some other photos unfortunately is just a suggestion, and I also simply don't have the information in front of me that there is a ticket number or a warning number, but there's no way to tell. So I do not feel that the city has proved by any means beyond reasonable doubt. That's it, Your Honor.
Okay, thank you. So in case number that ends in 4076, the allegation is that the defendant violated section 7620 of the Boulder Revised Code by having a vehicle that was parked for 72 hours without being moved. The evidence comes from Officer Croteau, who was clear and credible and believable in the court's mind. He indicated that on October 11th, he appeared and saw it was there for another reason to issue citations and begin a process for marking vehicles that might be considered abandoned under the ordinance. That he chalked the tires for the registration number 8784, which matches up to the vehicle for this particular occasion. And that he also looked at the valve stems on both of those for two different wheels. And when he came back on October 14th, more than 72 hours later, the chalk was still visible. None of it had come off, and the valve stems on two different tires were located in the very exact same place. And this evidence convinces the court beyond a reasonable doubt that that vehicle had not moved during that 72-hour period. And so I am convinced beyond reasonable doubt that there was a violation of 7620, and we'll find the defendant guilty of that violation.
Okay. Another guilty.
All right, let's turn to the next case that is listed here, which is the one that ends in 4077. That ticket number, and I'll pull that one up now. This is, again, a violation of section 7620 of the Boulder Revised Code for that same date of October 14th of 2024. So it's a similar allegation. Is the city ready to proceed?
Yes, Your Honor.
All right, officer, will just come back forward and have a seat. I'll just remind you, you're still under oath, sir.
Yes, sir.
Whenever you're ready, Mr. Reynolds.
Thank you, Your Honor. Hi again, Officer Croteau. Your Honor, I'd ask the court to take judicial notice of all of the intro testimony from the first trial, his name, where he works, his duties, how long he's worked here, and all of that.
All right, any objection to me taking judicial notice of the prior testimony?
No objection, Your Honor.
All right, thank you. I will take judicial notice of that testimony. Go ahead when you're ready, Mr.
So, Officer Croteau, October 14th, again, at mid-afternoon, around 2:30 p.m., around 2:40 p.m. Did you issue more tickets that day?
Yes.
All right. Well, I'm gonna just approach with what's been marked as people's exhibits 31 through 39 and hand them to Officer Cruteau. Would you mind just taking a look at these and then just look up when you're done? All right, Officer Cruteau, do you recognize those photos?
Yes.
How is it that you recognize them?
These are the photos for my citation.
And did they appear to be a fair and accurate representation of the vehicle as it appeared on October the 14th?
Yes.
At this time, I'd move to admit People's Exhibits 31 through 39.
Mr. Lau, any objections to exhibits 31 through 39?
No, Your Honor.
All right, exhibits 31 through 39 will be admitted.
Officer Cruteau, what vehicle is this ticket involving?
This is for a large trailer.
Is
Lone Wolf, thank you for coming by. We're going over several cases with Mr. Lau. It's just looked like the video's been repeating itself for the last 4 hearings. They're all small hearings. He got to get through those little tickets that he has. But thank you for coming through and bringing some people with you. So, yeah, we're just hanging out. They wanted to see the next hearing, so that's what we're doing. And getting through all these parking tickets that Mr. Lau has going on.
Is that trailer the license plate DAUH00?
Yes.
And who's that registered to?
Mr. Michael Lau.
And what was this ticket for?
This is going to be for abandonment, 7-6-20.
And was that 7-6-20? The ticket, was it the trailer, was it for being parked longer than 72 hours?
Correct. This is a result from the original checkout from the 11th of October.
Okay. And so what did you do on the 11th with regards to this vehicle?
So I had started it up on a watch, so I had received a warning. I had chalked tires on the driver's side, and then I also had documented where the valve placement was as well.
And did you do that before noon on October the 11th?
Yes.
And what did you observe on this vehicle on the 14th?
On the 14th, I had, after looking at the situation, I had determined that the vehicle had remained unmoved for 72 hours.
How did you reach that determination?
By looking at the physical chalk and then also the valve placement as well for the trailer.
And what were you looking for when you were looking at the chalk?
So I was making sure that the chalk remained undisturbed and that the valves were in the correct places per the 11th.
When you say correct, would you mean like the same place? Okay. And so on the 14th was the chalk. What did the chalk lead you to believe on the 14th?
Because the chalk was undisturbed, it had received the correct violation.
And what about the valve stems on the 14th?
And the same, that was also taken into consideration as well.
So had the valves moved from their location that you had observed them on the 11th?
No.
And was this vehicle parked outside of 290 Pawnee, City of Boulder, State of Colorado?
Yes, it was.
I don't have any other questions for Officer Cruteau on this ticket.
Okay, thank you for that, Mr. Reynolds. Mr. Lau, cross-examination for Officer Cruteau.
Thank you, Your Honor. Yes. You testified earlier on tickets 3988, which has since been dismissed, but that you actually chalk the trailer tires on October 11th.
Correct, yes.
Thank you. Now looking at the photos, exhibit 31 through 39, some of the contents and the arrangement of the trailer looks on these exhibits looks very different. Looks different than the ones that was used as that was submitted on for ticket 3988. Can you explain the discrepancy for the difference in the chalk mark? For example, the rear tire, the fact that for whatever reason, the license plate was dangling as opposed to being properly affixed in the previous ticket, well, in an earlier ticket for the 11th. And
Let's keep it to one question because it could be hard.
Sorry,
You have a tendency to kind of go off topic a little.
Okay, so
Tell him what exhibit you're looking at and then ask him a specific question as to what you want him to describe.
the exhibit, 33 does not bear exact resemblance to an earlier exhibit, because that was, you testified it was taken on the 11th. It's People's Exhibit 18 for ticket 3988. The chalk mark looks different to me.
Okay, so the reason why this was cited was because on October 11th, we had started a watch on this trailer for abandonment, and it would be ticket number 2421470. 3989 would have the photo evidence of the warning and the initiation of this abandoned vehicle. I did bring photo evidence if you would like to see it. I also have that as well.
Sorry, I actually don't understand what you just said.
Yeah, let's stop for a second. Let's get you back on to answering that question, officer, if you don't mind. He's referencing Exhibit 18. Mr. Reynolds, do you have Exhibit 18?
I can provide him with a copy of 18 here.
And then I'll try to rephrase the question so it's clear to what he's asking. As I understand it, what the defendant was asking is if you look at Exhibit 18 and then you look at Exhibit 33, he's asking you if there's any difference in those as two exhibits which relate to the same vehicle.
Oh, yeah. So, I mean, if you're just asking about these photos, the different angles, approximately the same items are in the trailer, and the same items are strewn about the city right-of-way, the street, and pertaining to the pallets on the lower left-hand area are the same. There's a metal crate that's on the back that's leaning up on the sidewalk and also onto the trailer that also looks the same. And there's multiple items in the trailer that also look the same and untouched. The only thing I guess you could say that looks a little different, and it could have just fell during the enforcement, was it looks like the license plate is a little askew in number 31.
You can follow up with additional questions if you have them for the officer. I think he's answered that initial question.
Excuse me, Your Honor, I'm still trying to compare and contrast. You said you have additional, when I couldn't understand what earlier you said. You said you have additional photos?
Oh, correct, yeah.
Of 11th I already have.
Yeah, so like we were saying earlier, was it 3988 for the camper
Yes.
RV trailer for that? Yeah, so and I want to say that's where our exhibit 18 is coming from. So when I was testifying during that, I had mentioned that on the 11th I had chalked the tires for that vehicle. That was for the abandonment that this ticket eventually came out of.
Oh, you saw what I did, huh? You saw that. That was good. You caught on to that. I was wondering who was going to see it.
So the photo evidence would be for this abandoned ticket where the warning had started. The last four digits are 3989. It was the next ticket that was given in succession to 3988.
Oh,
And I
there
did
was a
bring-
warning, 89,
Correct,
that
yeah.
is 89.
And I did bring photo evidence as well, if you'd like to see it. Here it is.
Yes, since I cannot reconcile the 18 and.
Do you want to step up and help Mr. Reynolds and show him what
think
photos
it's
you're talking about? And he can show them too. It'll be the same issue for you, Mr. Lau. If you choose to have those exhibits admitted. We'll have to mark them as defendant's exhibits, and you can secure the admission through the testimony of the officer. If you choose not to have them admitted, that's fine as well. I'm assuming that you're not intending on admitting them. Is that correct, Mr.
That
Reynolds?
is correct, Your Honor.
Just give me a quick second, Your Honor. Thank you, Your Honor. I have looked at the additional photos supplied for October 11th. So while I do see a difference, I have no further questions for the officer.
Okay. You can step down, officer. Any other evidence that you'd like to offer, Mr. Reynolds?
No, Your Honor.
Mr. Lau, any evidence that you'd like to offer in this case?
No evidence. Proceed to closing, Your Honor.
Okay. Closing argument, Mr. Reynolds.
Thank you, Your Honor. The people submit that they've proven beyond a reasonable doubt that this vehicle was parked on a city street longer than 72 hours as Officer Croto's testimony, that he was out to, on the 11th, to chalk and view valve stem placement on this vehicle. And then on the 14th, more than 3 days later, observed the same vehicle, and the chalk and the valve stem placement led him to believe that the vehicle had not.
All right, I see a lot of people asking. So when that attorney came up and gave the judge paperwork, it looked like I grabbed it because I stuck my hand out to grab the paperwork. So it wasn't nothing. But if you want to see it, just go back from here. You'll see what I did.
All right, thank you for that, Mr. Reynolds. Any closing argument from you, Mr. Lau?
Closing argument, yes, Your Honor. While I definitely acknowledge the photos that has already been submitted into evidence, to me, and even having the benefit of looking not only at the earlier ticket and maybe additional tickets that the officer said he provided as part of the warning, I see substantial discrepancy in it. In the official admitted into evidence photos for October 11th versus the 14th. So I fail to see how the city can prove that it has not moved once again for, in this case, 72 hours.
Okay. So I have heard the evidence. In this case, I heard testimony from Officer Croto that on October 11th, sometime before noon, he went to the residence at 295 Pawnee. He saw the vehicle with the license plate DAUH00. That license plate was registered to the defendant, Mr. Lau. That trailer was parked at that location on October 11th. He chalked it on October 11th. He chalked the tires. He also checked the valve stems for a couple of the tires. He returned on October 14th in the afternoon around 2:30 or 2:40 p.m. The chalk on the vehicle's tires was undisturbed, and the valve stems were in the same location. That is corroborated by the evidence that was provided. The photographic evidence also shows that the chalk appears to be undisturbed, and the valve stems appear to be in the same location where they were on October 11th. So the court is convinced beyond a reasonable doubt that in fact that vehicle did not move during that 72-hour period, and for that reason the court will find the defendant guilty of the violation. All right, we have one more trial. I think it's number 4078 for today.
Yes.
And I will pull that one up here momentarily. This is an allegation under section 7624B that on October 14th, a vehicle was a camper or trailer or RV was parked in violation of that provision, meaning it was outside of the defendant's residence for longer than 48 hours prior to that date. And is the city ready to proceed on that
The
case?
city is ready.
All right. Officer, I'll just have you have a seat again. I'll remind you, you're still under oath. Thank you. And Mr. Reynolds, whenever you're
Thank
ready.
you. Officer, Your Honor, I'd ask the court to take judicial notice of the introductory testimony, background, duties, where Mr. Officer Croto works, how long, and all of that.
Any objection to me taking judicial notice, Mr. Lau, of prior
No
testimony
objection.
from Officer Croto? Okay, I will take judicial notice of that.
Yes, this is the last one, I think. Yeah, it should be, because we're almost out. So I'm sure y'all are happy about this.
And whenever you're ready to
So,
testify.
thank you, Your Honor. So, Officer Croto, we're back on October 14th. The last ticket, I think, was issued around 2:41 a day. And I'm going to approach with what's been marked as People's Exhibits 40 through 45. Officer Croto, can you just take a look at these and then look up when you're done? Thank you. So Officer Croto, do you recognize those photos?
Yes,
How is it that you recognize them?
they're the photos from my citation I gave that day.
Okay. Did you take those photos?
I did, yes.
Did they appear to be an fair and accurate representation of the vehicle as it appeared on that day?
Yes.
I'd move to admit exhibits 40 through 45.
Mr. Lau, any objection to exhibits 40 through 45?
No objection, Your Honor.
Exhibits will be admitted.
And Officer Croto, is this vehicle in question license plate DAUH00?
Yes.
And that same day, it's accurate that you had ticketed that vehicle, that same vehicle for a different violation, correct?
Yes.
And so in this case, you ticketed it for a violation of 7624B, which is a prohibition on trailers being parked on city streets for longer than 48 hours. Is that accurate?
Yes.
Okay. And you had also given that trailer a ticket for just being a vehicle parked longer than 72 hours.
Correct, yes.
Okay. And because it's the same vehicle and because it's the same, did you follow the same process as you testified to in the last trial we had in terms of like viewing the valve stems and the chalking and all of that?
So for this one, I have evidence that the vehicle has not moved. Is that what you're asking? Or,
I guess I'll just ask it this way. How did you determine that why did you issue this ticket?
I had issued this ticket for a checkup. The vehicle, the trailer in question was on the street for 72 hours, undisturbed, unmoved. So per the checkup for the abandonment, it had received a ticket for abandoned, and then it also received a citation for trailer parked over 48 hours on the 72-hour mark.
I see.
Objection, Your Honor. Officers testifying to both tickets, 7-7 and 7-8. I thought we had just covered.
We've resolved 7-7. He's just he's indicating in his testimony that because he had already determined that the vehicle hadn't moved for 72 hours, he was convinced that it hadn't moved for 48 hours, and it turns out to be a trailer, so he issued a ticket for that as well. And he can do that. He can testify to the way he is.
So on that day, on the 14th, what led you to believe that the trailer had not moved for the previous 48 hours?
Because the chalk and the valve stems remained unmoved since the 11th.
And that vehicle, who is it registered to?
Mr. Michael Lau?
And was this at 290 Pawnee, City of Boulder, State of Colorado?
Yes.
And so you applied the chalk on the 11th,
Yes,
and you had observed the valve stems on the 11th?
yes.
And then on the 14th, they seemed to indicate to you that the vehicle had not.
Correct.
At this time, I don't have any other questions for Officer Croto.
All right. Any questions from you, Mr. Lau?
Yes, Your Honor. So I know we're talking about ticket 78, but on ticket 77, you have testified and the court has ruled that it was parked over 72 hours. Hence, the ticket is and the citation is valid. In this specific one, 78, the ticket is for park for over 48 hours. Your Honor, sorry. Isn't there a double ticket fine for the same thing? I don't know the legal term. I'm not asking you, but.
You can make a
why would
legal
you-
argument at the end of the trial. You can make an argument about that.
So you feel that you wrote the ticket even though you wrote just 1 minute before that, the 72-hour? So if that would have been a 24-hour thing, you would have written a third ticket?
So what I did,
Yeah.
so I granted you an extra 24 hours as a courtesy, as opposed to giving you a ticket on that 48-hour mark. We waited 72 hours to give that to you. In good faith.
Sorry, I don't understand your testimony. 77, you was for 72 hours. You wrote me a ticket.
Yeah.
1 minute later,
Mhm.
you said, I misunderstood you. You said you extended courtesy because it's 48 hours. You still write another ticket for a 48-hour violation. I may have misunderstood you.
I do apologize. So for that citation, we could have been there 24 hours and given it. We waited an extra 24 hours to give you an opportunity to move everything because you had so many items in the street. So instead of enforcing it on the 48 hours, I enforced it on the 72 hours.
So the your chalk mark being placed on the 11th, whereas you said you extended the courtesy of the 48 hours, would made it a Sunday. Should you have tried to enforce that, which I don't believe your department operates on a Sunday. I guess both the police does, but sorry, I don't understand what courtesy you say you've the additional 24-hour courtesy, because you would not have shown up on a Sunday anyway. Or is that department rule that you can make?
I'm unsure of the question.
You said you extended additional 24 hours.
And the vehicle remained unmoved for 72. That's why you received the ticket.
But that was ticket 77.
I'm talking
But now-
about ticket 78.
Yeah, 78 is
That's what I'm talking about.
for 48 hours. But you actually, now for this ticket, you testified that you actually extended a 24-hour courtesy window for me.
Correct, yeah. So we didn't give you the ticket right at 48 hours. We gave it to you on 72 hours. I can't make that any more
I
clearer.
think what he's saying to you is he could have come back after 48 hours and issued you a ticket for.
On a Sunday, Your Honor.
He could have done that. He said
Really?
he didn't do that.
We do operate on Sundays sometimes.
Sometimes.
There's nothing in the code that tells people that they can't get tickets on a Sunday. So it's just, he's just saying that he gave you a ticket after 72 hours, which he says he could have given to you after 48 hours.
Your Honor, I'm only relying based on information I've read at the website.
It may be that they don't work on, they don't
Saturday-
typically work those days, but he
Yeah.
could have.
Monday through Saturday is something until 7 p.m. I believe I'm correct on that, right?
There's
Okay.
normal scheduling, but there is
Yeah.
also hours outside of that we operate.
All right, I see where he's getting at. Now, I'm not taking Mr. Lau's side, but he is making a point because they bought that other ticket back up that they just settled. And then he's saying from the last ticket that he gave him extra time on this ticket. And I think if he worded it correctly, he can make him actually answer the question, did you work on that Sunday, whether it's relevant or not? But I see where he's trying to go with it. But and let me know what y'all think in the chat. But I understand where he's trying to go. He's just not doing it right.
No further questions, Your Honor.
Mr. Reynolds, anything from you?
Your Honor.
Officer, you can step down. Any other evidence for the people?
Be rested.
All right. Mr. Lau, any evidence that you'd like to offer on case number 4078 in testimony?
Proceed to closing, Your Honor.
Go to closing argument. Mr. Reynolds, closing on that one?
Yes, Your Honor. Officer Croteau testified that checked on the 11th and then checked on rechecked on the 14th, and that the vehicle, the trailer, had not moved and was there longer than 48 hours. Now, I do understand that the trailer had received the 72-hour ticket as well. I think there's an argument to be made that there's a difference between a smaller vehicle, like a regular, like that blue truck being parked on the street, having less of a community impact than a long trailer such as this. And so I don't see a legal, I don't see any legal error in ticketing the trailer for both being violating the 48-hour prohibition as well as the 72-hour prohibition, especially given the fact.
Well, y'all are probably right, but I knew what he was trying to get at. That's why I explained it. I was like, okay. He want to know basically, did he work that Sunday? And trying to say, well, you didn't give it to me. You just wasn't working. But somebody else could have came and did it if they were working. But his area was already hot because they come through there every day looking to give him more tickets because he doesn't move anything.
Yeah, so I don't see that being duplicitous or legal error.
I'm glad you made your argument because I was going to ask you to comment on that. So, Mr. Lau, you can make your argument as well.
So prosecutor in essence single out this particular trailer versus the blue truck, and this trailer, in his opinion, because it's longer, fits in a separate category for enforcement. That and the court has already ruled that, of course, that the 72 hours is valid. I don't know, Your Honor, I don't know what the legal term would be, but to me, being ticketed for two within 1 minute of each other, and based on chalking and evidence supplied by the city, starting on the 11th and ending on the 14th, is it defendant is being subjected to double jeopardy, which is, I believe, totally against civil or criminal law. So I'm defendant for two, in essence, for two similar things, identical, to me identical, but
I'm gonna answer two things. So yeah, I think Rhonda mentioned something about they should have told it. And then Nerdo, what you're saying about the boot, that makes sense too, because I know places that do that, but it seemed like he always wanted to keep his vehicles there. So if they do have the boot, they were like, no, they'll be basically helping them out. He'll probably never move those trucks.
the prosecutor's argument is because it's a longer trailer, so it should be punished a second time. So, Your Honor, I fail to, not being a lawyer, I fail to understand the legal rationale on being punished without twice for the same trailer. In this case, based on the same chalk mark that was handed out on the 11th. While the codes may appear to be a little bit different, the essence and the spirit of the enforcement in this case is the same trailer, once again, over in essence, the same period of time. Same period of time being defined as the start of enforcement monitoring. This was the 11th. And now, then I'm given two separate tickets and being called two separate things.
I understand the argument. All right. So first of all, let me make a finding in case number 4078. The allegation was that the defendant had a vehicle that was parked for more than 48 hours on a city street in violation of 7624B of the Boulder Revised Code. And that was, in essence, that it was parked in front of a house that the defendant was a resident, but it was there for longer than 48 hours. And the city has established that there was this violation. Officer Croto's testimony was clear and credible and believable, that Mr. Lau is the owner of a vehicle with a license plate DAU H00, that on October 11th, that vehicle was parked on the street. When he came back on October 14th, that vehicle was parked in the exact same location. It had not moved because he had, obviously in his testimony earlier on a prior case, had already testified that the vehicles, he had checked the valve stems, he had checked the chalk, they were chalked it actually on the 11th, and then checked the valve stems and the chalk on October 14th, and that vehicle had not moved. But I am challenged slightly by the fact that these are the exact same factual basis for the exact same circumstance. And so in my view, they have merged. It's not a double jeopardy circumstance, but I think you were trying to find the language that might apply. In my view, they merge. It wouldn't be the same if someone had a license plate violation and was parked in a meter and given a ticket with multiple charges, because there's two different factual bases that provide the evidence to support each of those particular violations. So if an officer comes on the scene and says, boy, I see this vehicle, it doesn't have a license plate, it's parked in violation of a meter, there may be even some other violation that the officer might see. If there's a different factual basis for which to issue and there would be a different proof at trial, then they don't merge. But in this particular circumstance, I find that although the defendant was guilty of the violation, the fine, I'm going to suspend the fine on that one because I believe it merged with case number 4077. So I'm entering a guilty finding, but I'm suspending the $75 in fees and fines on that particular violation of section 4078 based on a merger legal analysis. So that resolves what we have for all of those tickets, 3985 through 4078. It leaves us with a large number of citations left to determine, but it took us 2.5 hours today to do
Faster than last time, Your Honor.
I wasn't clocking it from last night. My point is we probably, I'm looking at what we've got left, and it's a pretty lengthy list, but I would suggest that we might be able to do all of the tickets that were issued on the 14th thereafter. And then I'd be willing to hear argument as to whether we ought to also try to do those tickets that were issued on October 22nd, Mr. Reynolds, but that would be more like 12 tickets, but two separate dates. We still have some from the 14th that were issued, and then so if you wanted to ramp up the way that we're approaching this, I've gone straight to that point. I know that you all have had time to occasionally have conversations. We've now had 2 dates full of trials. If it makes sense for there to be conversations, I'll certainly entertain that, but if we want to simply set trial dates, we can do that.
May I, Your Honor? Yes, I am, as always, open and receptive to a conversation, hopefully productive with prosecutor. However, as I asked the court earlier, and Your Honor, you said you will address it, what does the, I believe once it's in court, it is not subject to the whatever the time limit on payment or whatever it is, of course, until, Your Honor, you rule on it. So I'm back to the earlier tickets that has been already sent to collection. Now I'm also trying to address, and this is the fine issue, how do I know what is coming up fine-wise, that it would have hit already the
14
scaffold law, so it can be towed on site and all that stuff. It can be booted and towed on site. So I have no reference, Your Honor, on how that may or may not transpire. So I need clarification and ruling from the court before we can try to deal with the additional ones. I am at a loss on how to deal with including what has been decided today.
Let me make sure I understand what you're asking. You're asking me to tell you which tickets, number one, you still have a right to trial on?
No.
No?
Your Honor.
You're asking me to tell you which tickets are for which vehicles might be eligible to be towed?
Yes. As well as what vehicles has been sent to collection, or if of course, as Your Honor, as you recall, I do on specific fines and so forth, I definitely wish to try my best to fulfill those. But when I have absolutely no clue the amount and time frame and so forth, and whether it's even valid as we speak right now or not, Your Honor, there is no way that I can even try to address not only the past ones, but the new trials that will be coming up on certain tickets. I just simply do not have the information. Whether the prosecutor or the court can furnish me with that at least would allow me, hopefully, to be able to discuss.
So I'll have Greg, I think we've done this before where Greg has printed out.
Yes.
And it doesn't, am I reading this correctly that there haven't been any new tickets since December 13th? Or is that not correct?
It's probably more or less correct because an officer was courteous and appeared and arrived this past Friday, but advised me to move vehicle and so forth, and not issue me a ticket. He of course took photos. I'm sure the photo parkings were.
There was one ticket that was issued on December 2nd, and so when you were here last, that ticket was issued, and then the next ticket I see is one from December 13th. So I want to just.
That's probably true.
And so the good news is, from the court's perspective, is we've only had one ticket issued since in that time frame from December 2nd to today's date. So over the month, there's only been one. Now, it doesn't mean that they couldn't be issuing more, but perhaps they're holding off. I don't know. So there's one, all of those tickets that were issued, because of the way this has proceeded, in fairness to you, I'm still allowing you to have trials on all of the ones that are after that October 8th date. I think I mentioned to you, and that's why we're moving forward with these others. As far as collections or potential to be towed, Greg, you would have to show me on the system where I could see if there's been any courtesy letters or scofflaw letters issued to the defendant on any of these vehicles.
Your Honor, at least I have not received any.
So we
Thank you.
haven't sent any letters since the cutover to Ames,
To Ames.
since late November.
Okay.
It looks like there
Were some that were on the tow list when we were on T2.
I'm seeing 3 vehicles.
I think those were moved,
on the
right?
list.
Yeah, do you want to tell them the license plate numbers for those that were on the tow list? And I remember that, Mr. Lau, we talked about this when you first came to court. You had a few vehicles that were on the tow list,
Yes,
and I think you moved those vehicles into a
Yes.
storage area.
yes.
So
But-
Greg's going to just tell you what 3 vehicles they were if he's able to.
Your Honor,
You
sorry.
can confirm
But
that.
based on the fines that has been levied and based on the late fee, once again, once it hits, is it a 125 or 150? Including late fees, that's on the stuff.
So I'll answer those
So-
questions. Don't put the officer in the question or
Can I
Mr.
release the
You can, all the witnesses are free to go. Well, and, I mean, I'd like to get our next trial date scheduled. So maybe let's have this conversation in a moment. We can go back. Let's talk about process of where we are with trials. And then I'll come back and answer those questions and we can let these
Thank
folks.
you, Your Honor.
But I think it's pertinent right now to determine the trial date and whether we want to try to do just those tickets that were issued on October 14th, or whether we want to try to muscle through the tickets. We can set a trial date. If you all want to have a conversation at some point and see if you can resolve these things, I'm certainly open to that. It's a tremendous amount of resource for everyone here, parking officers, Mr. Lau, and the court, to have trials, but the defendant is entitled to trials. So if you're not able to resolve this, that's perfectly fine with the court. But let's start with that. Mr. Reynolds, you're seeing those, it looks like, I think it's 12 tickets that we could try to do on one morning or afternoon, or we could just stay with the 6.
I think unless we scheduled the trial earlier or wanted to stay much later than regular business hours, it'd be my position to try to do 6. I think
Okay.
6. I think we try to do 12. Well, unless they're all like expired license plates, if that's the majority of them, then we could probably do 12. I mean, what we could do is we could schedule 12 and then say like during the trial day, like any ones that we haven't got to by 4:00, we'll just schedule for a different day. So we could try to get through 12.
I think that makes some sense. I think that makes a lot of sense, is we would try to schedule, and on this printout, Greg, that I have, it's going to be 4079 all the way up to 4242. Basically anything that was issued on October 14th or issued on October 22nd, and that there's a dozen that we would schedule. Let's look in our full court database and try to figure out when we want to schedule that trial.
All right.
And you heard Mr. Reynolds. I think it's a good idea, Mr. Lau. We'll schedule 12.
Yes, no,
If we can get through all 12, we'll do it. If we get to a point where it's 4:00 or later, we'll
I
stop and we'll
concur
reset.
with the prosecutor because there is absolutely no reason to extend it into after work hours for the officers involved because they have both professional and personal life.
Thank
and
you
I
for
see no
understanding
reason
that.
to.
All right. So today is the,
He must like to be in court all the time. And honestly, if with that many tickets, if he comes to court and they find him guilty, it needs to be a fine on every last one of them. I don't think the fine should be, waived, because this is wasting a lot of court time. And if that officer is off on that day, or was off on that day, he's getting straight overtime just to sit in there for this stuff.
14th of January. This week is out. Next week, challenging, I think, when we look at what we've got available. The following week, the 29th, that week of the 27th through the 31st. Let's just take a look.
I will not be working that week.
And you're going to be the trial lawyer on that one.
I'm
You
hesitant.
haven't pushed it on anyone else
I'm
yet.
hesitant to, just because of institutional knowledge of parties and all of that, and so we
Appreciate
could
it.
not do it that week. That would
Okay.
be my-
Let's take a look at February, the first week of February, the 3rd. Won't work. The 4th won't work because it's just starting times. The 5th, we could start, but that wouldn't be till 2.
No, we'll never finish 12.
Well, let's take a look at February 7th. We could start at 1:00 that Friday, the 7th. I don't have anything scheduled yet that afternoon. Mr. Reynolds, do you want to check with your witness?
Your Honor, don't you?
Sean and we got each other's availability pretty good, so he's available that day.
Okay, February
Your Honor, don't you
7th
have traffic courts
in the morning.
typically Friday afternoon now?
The parking add-on docket, we won't have that afternoon. I can.
No, yeah.
So
I appeared the first time ever because of that.
yeah, but we
So
won't
that's
have
the
it that
only-
day. We would just have the,
That would be, yeah, of course.
so
yeah.
we're looking at February 7th. Let me just double check.
Oh, you do?
At the 7th.
Okay.
Oh, doesn't work.
He usually works Monday through Friday, but not that Friday.
Not that Friday.
And it's 2.5 times.
Let's look at February.
It's okay, we'll just show up.
We have February 10th, which is a Monday. We could start at 1:00 on that February 10th. Let me take a look at February 11th. We could start at 1:00 on the 11th,
I would prefer the 11th, if that's available.
Tuesday, the 11th.
Tuesday, the 11th, is fine. Yeah.
Let's schedule it for Tuesday, the 11th at 1 PM, Greg. Unless you tell me we shouldn't, but it looks like we've got just a regular criminal docket in the morning and then nothing in the afternoon.
I will put a trial slot at 1 PM.
Okay. So we'll reschedule. Now, you'll need to double check and make sure that you've got there may be other officers that might need to be witnesses. You'll have to look through all those tickets that get,
I think it's all officer.
okay.
So,
You're gonna be way too familiar with our court, officer. All right.
Your Honor, I am more familiar with your court by now than any of the officer here.
I don't think it's funny. He's wasting the court time on this stuff, and now he seems to be enjoying it.
Okay. All right, we will schedule that. And it'll be a new case number.
Yeah,
Yes.
I will have to create a new case for Tuesday the 11th. And I will email to everybody once the case is created, I'll email to everybody the case number and all the particulars.
And I will just stress for the parties, everybody has a right to trial. Mr. Lau has a right to trial. If you all can find a way to resolve these cases, the court's going to be amenable to whatever resolution can be reached by the parties.
Thank you.
See if I can set up a time to talk to Mr. Lau.
Okay, sounds good. Greg's going to get you want to just email the study notice to
Yeah,
everybody?
so I'm gonna have to create the case. I have to
Yep.
email a dozen tickets.
Yep. Okay. Thank you, everybody.
Thank you, Your Honor.
Have a great afternoon.
Thank you, Greg.
Sure.
Thank you.
Uh,
Have you already entered the findings on all of these?
Yeah, I did.
How they want to get it, it's kind of relevant as 407A, is you'll just spend the fine on that one.
Yeah, I found him guilty. Full court doesn't maintain the fines in the full court, they're maintained in Ames.
Yeah,
So the one that was not guilty
Thank you.
was waived in Ames, and then it was guilty, but I had to waive the
Oh, yeah, I
fine
know.
on that other one.
Forget.
Yeah.
He still owes $3,200.
As soon as I walk outside.
that's totally good.
Enough of that. Now y'all have had y'all nighttime. Well, it depends on where you're at. Your nighttime story, so you can go to bed. And Wildflower, thank you for giving out the popcorn tonight and making the last call. I really appreciate that. So yeah, we've been on here for a while, but y'all asked for it, that's why I'm still running it. The case is interesting, but you got to get through some of the nonsense sometimes in these cases. Sometimes they're slow in the beginning and you have to listen to a whole bunch of stuff. Then it ramps up a little bit. Y'all watch a lot of court, so you know how it is. But thanks for hanging out. This is ridiculous. Can't believe it. So I'll do the next one if y'all want to see it. Just let me know. I'll put it up. Oh, thank you. Yeah, I wear them sometimes now because I'm on the computer all the time making the content and stuff. So this is supposed to help my eyes relax. But yeah, thanks for hanging out. Oh yeah, thank you, Cool Clear Water. Hit the like if you haven't before you get out of here. And I enjoyed all the comments. We had a lot of fun, but yeah, second win. I'm about to get off. I got to put some stuff up for y'all for tomorrow morning. I got to finish that. And yeah, something will be out first thing in the morning. And I hope y'all have a good night. Yeah, I love y'all too. We're all in this together. All right, we're going to suffer together. That's how you feel? We can do it. We can do it. All right, the next. Yeah, I do. So I'll see when I run. I got to see how long it is. We've been really hanging out 2.5 hours, kind of regular. So thank you very much, Rhonda. Thank you very much. I'm working on it. It's these hearings I'm trying to keep up with, but I got you, Wolf. I got you. Yeah, something's gonna come up. Appreciate it. Yeah, appreciate that, Rebecca. All right. Okay, yeah, appreciate that. I'll see you on the next one too. Yeah, we had a good time. All right, so I'm sure a lot of you had your pillows. Now you can take your pillows and take them to bed. I'll see y'all around the next time.